The item number 1 and 2 will deliver order at 2 p.m.
Wait, please, Your Lordship. Your Lordship, I beg to mention listing of 2 MFAs on the order column after due vacation.
Yes. 29th.
Much obliged.
May I please, Your Lordship, I beg to mention item number 29, my lord, for orders. My lord, kindly pass over for a month, my lord. The service report is not complete, my lord, in this case. Item number 21, my lord.
29.
21. My lord, kindly, this matter may be fixed on first week of May, my lord.
Oh, what is the stage?
My lord, this is for
Service.
service, my lord. Service is not complete, my lord.
We will go through the record and pass orders when the matter is called.
Yes, my lord. My lord, I have another item, my lord, in court number
You
2,
need
my lord.
not to be there. I'll show your presence.
Yes,
I'll
ma'am.
show your presence.
Yes, my lord.
May I please, Your Lordship, I beg to mention item number 28, Lordship. Kindly adjourn for the
20.
28, 28.
Have you informed the other side?
Yes, my senior is informed the other side, Lordship. And my senior is out of station, Lord.
You have informed the PP.
Not, my senior is informed the other side, Lordship. I'm not informed. My senior is out of station, Lordship.
Heard, Mr. What is your name?
Islam, Lordship.
I Islam Learned Counsel for the petitioner. Who is your senior?
N. Ahmed, Lordship.
Appearing on behalf of Mr. N. Ahmed, Learned Counsel for the petitioner. Heard, Mr. So appearing on behalf of Mr. N. Ahmed, Learned Counsel for the petitioner, who prays for an adjournment on the ground that the conducting counsel for the petitioner is out of station. He submits that he has informed the learned counsel for other side regarding his prayer for adjournment, who does not have any objection to same. Hence, the prayer is allowed. Let this matter be listed. 29th of April. 29th of April.
May please, Your Lordship, I beg to mention item number 36, 37, and 38 for adjournment. With the consent of other side, Lordship may please list this matter in the first week of May.
What is your name?
U. Bihani.
Heard, Miss U. Bihani, learned counsel for the respondent.
Appellant, Lordship.
You-
Sorry, appellant and respondent both.
Learned counsel for the respondent in MFA number in item number 36 and 36 and 36 and 38 and appellant in item number 37, who prays for an adjournment on the ground of personal difficulty of conducting counsel for the appellant. She submits that she has informed the learned counsel for the other side regarding her prayer for adjournment, who does not have any objection to the same. Hence, the prayer is allowed. Let these matters be listed on 9th of June.
Much obliged, Lordship.
Admission, item 3. May it please, Your Lordship. This FAO is under Order 43, Rule 1R, Lordship, against the impugned order dated 4/5/2017, page 54, Your Lordship. The petitioners are plaintiffs. They filed a suit, Lordship, that was
along with the injunction petition, injunction was rejected only on the ground that second paragraph, on perusal and after hearing what transpires is that plaintiff had instituted this suit for specific performance of contract. Page 50
Just a minute.
54, Lord.
Last page.
Last page, Lord.
Yes.
On perusal and after hearing what transpires is that plaintiff had
Page
instituted
54.
54.
Yes. Yes.
Second paragraph. On perusal and after hearing what transpires is that plaintiff had instituted this suit for specific performance of contract allegedly entered on 22/2/2015 by defendant number 125 in respect of suit property for a consideration amount of rupees 9 lakh in favor of the plaintiff by taking an earnest money of rupees 50,000 and by delivering the possession of suit land to the plaintiffs with an undertaking to execute and register the sale deed after receiving the balance consideration amount of rupees 8,50,000 within 2016. Now, as the plaintiff has based his case on the strength of unregistered sale deed and also claimed that he has taken the possession of suit property in part performance of his contract, so I am of the considered opinion that in the light of provision of law laid down under Section 35A of Transfer of Property Act, read with Section 17(1)(a), 49 of Indian Registration Act, read with Article 23, a Section 28, Section 35 of Indian Stamp Act, I am of the considered opinion that the plaintiff has no prima facie case in his favor to get the relief of injunction as prayed for. Against this present FAO was filed, and while issuing notice, status quo was granted. So Lordship, since 2017 till today, there is a status quo.
Now, what is the status of the suit?
Suit, Lordship, at the argument stage, plaintiff filed a petition for forensic expert opinion on the unregistered document, and that matter is pending for report from forensic laboratory. But at the time of argument hearing, I have checked from online also.
It is at the stage of argument.
Yes, Lordship. That was allowed, and thereafter it is waiting for the report from forensic. I have checked from online also, it is reflected that for report. Next date is 1/4/2026 for report of expert. Thereafter, I have not.
Yes, Mr. Rajbur Bhuya. You are maintaining status quo.
Yes, that is with respect to the suit land, my lord.
Let the status quo remain because suit is going to be
Finally,
final disposal.
the last stage, my lord.
Lordship. And after that, this order will also have no value, Lordship.
Yes.
As soon as the suit disposed, the status quo will also go, Lordship.
Yes. What is your sub?
She is seeking for the injunction, my lord. At this stage, what is the meaning?
No, if we dispose of if you agree to maintain status quo till disposal of the suit,
Yes, my lord.
on that undertaking, this appeal may be disposed of.
Lordship, since 2017, no modification. IA was also filed by the respondent. When the matter was listed, it was informed the
It
respondent.
was not affecting us because my suit was proceeding only in respect of the suit land. We are in possession.
So we may dispose of it
Yes, it is
on,
lost, but
on your undertaking that you will maintain status quo till disposal of the connected suit. As the suit is in last stage.
yes, my lord, there is no problem, my lord. We are in possession of the land. Those they are telling that by virtue of the payment of rupees 50,000, they are in possession. No, it is not correct, my lord. Factual part is
merit
we are
of
in
the
possession. So it will not harm, my lord.
No, considering the stage of the
Okay,
connected
good.
suit,
Yes,
we may not go into merit stating with, because trial court has observed that they don't have prima facie case.
In
If
spite
I,
of that, the suit proceeded.
if I make a observation now, it may have a bearing on the outcome of the suit. So if you agree to maintain status quo, we can dispose of this appeal.
There is an order, already there is an order that today endeavor should be made to dispose of the matter.
Okay. Heard. Miss R. Chaudhary, learned counsel for the appellants. Also heard Mr. M.H. Rajbor Bhuiya, learned counsel for the respondent number,
The private respondents, my lord.
learned counsel for the
Government is there, Lordship.
respondent number 22,
6-7, GA Assam, 6-7-8. 1 to 5. And one was subsequently
Strike out.
substituted.
2 to 5. Also Miss M. Kalita, learned government counsel appearing for respondent number 6, 7, and 8. This appeal under Order 43, Rule 1 within bracket R of the Code of Civil Procedure 1908 has been filed by the appellants, impugning the order dated 4/5/2017 passed by the Court of Learned Civil Judge Karimganj in Miss Case number 111/2016 arising out of title suit number 33/2016, whereby the prayer for grant of temporary injunction by the present appellant during the pendency of the aforesaid suit was dismissed. The facts relevant for consideration of the instant appeal, in brief, is that the present appellant had filed a suit for specific performance of contract
Yes,
as plaintiffs before the Court of Learned Civil Judge Karimganj.
at present, the
The
same is present before Civil Judge 3 Senior Division.
within bracket presently the said suit is pending before the cut it out. The said suit was registered as title suit number 33/2016. Stop. Presently the said suit is pending before the Court of Learned Civil Judge Senior Division number 3, Shri Bhumi.
TS number 42, 2022.
The registration number of the title suit has also been changed to title suit number 42
42/2020.
42/2016.
In between, there was another number, title suit 467/2021, which was adjudicated before Civil Judge Junior Division.
And miss case number,
Miss case number.
it remains same because it was
it was
disposed of.
disposed of.
In the aforesaid suit,
Is
the
111/2016.
present appellants also filed an application under Order 39, Rule 1 and 2 of the Code of Civil Procedure 1908, praying for grant of temporary injunction against the private respondents. However, by the order dated 4/5/2017, the trial court declined to grant any relief under Order 39, Rule 1 and 2 of the CP Code of Civil Procedure 1908 to the present appellant. The aforesaid order has been impugned in this appeal. At the outset, the learned counsel for the appellant submits that at the time of when is the status quo order was
14/6/2016. Let us go till returnable date, and that was continued till today.
at the time of issuing notice in the instant first appeal on 14/6/2017, this court directed both the parties to maintain status quo in respect of the suit land. The said order of status quo is still subsisting, as even after appearance in this appeal by the private respondent, no application for vacation of the aforesaid status quo order has been filed by the private respondent. She further submits that in the meanwhile, the title suit number
42/2020.
33/2016, which was renumbered as title suit number 42/2022,
2022.
has proceeded and has reached its final stage and presently final stage of argument. Stop. She submits that in view of the progress made in the trial of the connected suit, the status quo order issued by this court by its order dated 14/6/2017 may be directed to be continued, and this appeal may be disposed of on that terms. On the other hand, Mr. M.H. Rajwar Bhuya, learned counsel for the private respondents, has submitted that has confirmed the submissions made by learned counsel for the appellant to the extent that the connected suit, that is title suit number 42/2022, has reached its final stage and is pending at the stage of argument. He submits that he does not have any objection if the status quo order granted by this court by its order dated 14/6/2017 is allowed to be continued till the pendency of the aforesaid title suit. You have any submission? So, after considering the submissions made by learned counsel for the parties, this court is of considered opinion that since last 9 years, the 9 years status quo, the parties have maintained status.
More than 8 years.
Since last more than 8 years, the parties here to have maintained status quo in respect of the suit property in pursuant to the orders dated 14/6/2017 and are agreeable to continue to do so till the pendency of the connected title suit number 42/2022. In view of the submissions made by learned counsel for both sides, this court deems it proper that instead of deciding this appeal on merit, it may be disposed of on the basis of submissions made by learned counsel for both the parties, more specifically by the learned counsel for the private respondents, that the private respondent are agreeable to maintain status quo. As such, this appeal is disposed of with a direction that the status quo order granted by this court by its order dated 14/6/2017 shall continue till the pendency of the connected title suit number 42/2022. The trial court is directed to dispose of the connected title suit as expeditiously as possible. With
Let us go over the suit property.
status quo over these two suits.
Ultimately, suit property as per the status quo in our possession. Though they are telling that is, but it is very
No,
much in our
injunction
possession.
prayer was for not to alienate. We are admitting they are in possession.
Okay.
We are not annihilating the matter. my lord.
Then okay.
But that is better for us.
In between the family members, my lord. Cousins, they are cousins. And we are.
Incline,
sisters, we are in
incline. Mind you, Mr. Rajbar Bhuya, he further submits that the private respondents are not going to alienate the suit property during the pendency of the connected title suit number 45, 40,
42 of
42 of the 2022. Okay.
Much obliged.
Item 4. This is an appeal under section 299 of the Indian Succession Act against the judgmental decree passed by the learned district judge in a probate petition.
Probate was granted.
Probate was granted. This being a statutory appeal, Lordship will admit the appeal, but so far as interim order is concerned, my lord, I would like to only submit one thing, my lord. Here is a case, the lady, who was the testatrix, she died intestate and without any children. So in view of section 15, subsection 2B, after her death, my lord, normally property will revert back to the legal heirs of her husband.
Parties are
They are all from Assam, my lord. So they are Baga. And the learned district judge also made another error possibly, holding that Mitakshara is
no, whose will was
will
probated.
of the lady who died intestate. She inherited her husband's property.
No, that is your case that she died intestate.
No, it is admitted fact.
Then
Admitted fact is she died intestate. She, in the will, she given the property to her sister. Then this much is admitted fact. Right? Your Lordship is aware under section 15 2B. I'll just read the provision for a moment.
no, she executed a will.
Yes.
Then 15 to be
15 2, that's why I'm making this
it will be applicable if she died intestate.
intestate. That's what I'm
If
saying.
she had made a will,
Absolutely.
then 15 will not be applicable.
No, so it will not be applicable because will itself, my lord, it is a settled law that will itself is to cut the normal
Yes,
line of succession.
yes.
What I'm saying, my lord, this is one circumstance which creates suspicion.
What suspicion?
That, and this is one. Secondly, my lord, she
Oh,
has
what is the one first, sir?
first submission, my lord, she is deliberately cutting the normal line of succession. All right, she can.
She can.
She can. I'm not saying that she cannot. She can, but Supreme Court says if the property property is bequeathed in unnatural way. This is one unnatural fact that normally it would have gone to get back to the legal heirs of
No, she
husband.
can will it to anyone.
She can.
What is the unnatural?
Well, unnatural because she has deliberately it's not a case where someone was there to take care of her and she wanted to give the property. For the time being, she was taken to the house of the parents of the propounder. During that time, the will was executed. Husband is not there.
Okay.
This is one.
Second-
Secondly, madam, the law is very clear, madam. If the propounder gets substantial share of the bequeathed property and he or she takes major major role in the execution of the will, then this itself creates a suspicion and it is the burden of the propounder to remove that suspicion. But learned court below has said that no, the defendants have alleged fraud, they have to prove, burden is on them, there is no burden absolutely on the propounder or the petitioner.
Okay, this has to be examined in this appeal.
My lord.
Will
What
I-
I am saying, my lord, the person, the lady who got the property, sister, she is married, she is residing in her husband's place. This was under lock and key. Now, moment this order was passed, they have come and started cleaning and all. So Lordship will pass some order protecting the property, otherwise they will start taking the benefit of this illegally granted will. This much.
Okay. In appeal, heard Mr. D. Majumdar, learned counsel for the learned senior counsel, assisted by Mr. S. Bishwas, learned counsel for the appellant. This appeal under section 299 of the Indian Succession Act, 1925, has been preferred by the appellants, impugning the judgment and decree dated 6/2/2026, passed by the Court of London Additional District Judge within bracket FTC Sonitpur in title suit within bracket P number 2/2022, whereby the petition filed by the respondent under section 276 of the Indian Succession Act was allowed and probate was granted in respect of the will dated 9/2/2021. I have gone through the grounds stated in the memo of appeal. Have and also considered the submissions made by learned counsel for both sides. Senior counsel for the appellants. This appeal is admitted. Let the notice be issued to the respondent. The appellants shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 22nd of May. Let also the records of title suit within bracket P case number 2/2022 be called for from the concerned trial court. The registry to take steps regarding requisitioning of the aforesaid records list accordingly. IA is there. We are issuing notice in IA.
Well, some protection because it is under lock and key now. House is lying in the lock and key, and the propounder is already living with her husband in a separate place. They have got their own house. Now they have come, started cleaning, and also they will occupy it. It's under lock and key. I'm praying for stay.
No stay now. After we will issue notice.
Then status quo as on today what she may have done. So otherwise they will enter into the house and the situation will be different. My lord. It is under lock and key. Lord, you may record my submission.
They are entitled to enter.
She died, my lord.
Till your appeal is allowed.
My lord.
They are entitled to use that property.
My lord, it is under, first of all, it's under lock and key, and her husband was entitled to 1/9 of the property, and she has, which comes to 20, let's say there's 1 katha, and she has bequeathed 1.5 katha. There also Supreme Court is very clear, my lord, that she cannot bequeath more than her share. I brought the judgment, my lord.
Let the notice be issued. We are, command date this, 22nd May.
What I'm saying is they will start, open the house and they will start residing there, which they have done until now. Lordship will protect the property. I'm not saying that it should be given to me or
No. How it, what is your apprehension that how it will be damaged by their use?
apprehension are two, my lord. One is there, not entirely, they will start using. Secondly, my lord,
No, use, there cannot be a bar to use once they get the probate of the.
my lord, and secondly, they may create third party, right? They may sell it because they have got their own.
What is the
separate-
basis of your apprehension?
My lord,
There
because
has to be some basis.
This is because they have filed the probate in order to become owner of the property. They have,
Yes.
the will, probate has been granted. And if they sell it to a third party again, I'll have to proceed against them.
No, but that is mere Is there any basis that they are doing something?
Till now, they have not taken a step, but
And
this is my opinion.
So we are issuing notice. Issue notice in May, fixing 22nd May.
But on the returnable date, interim order may be considered. After the APR, interim order may be considered, that may be met.
Okay, the prayer for grant of interim order may be, shall be considered after due service of notice on the respondents.
Item 5.
May I please, your lordship, prayer for enhancement.
Heard Miss. What's your name?
KLR Yantan.
Heard Miss KLR Young Thun, learned counsel for the appellant. This appeal under section 173 of Motor Vehicles Act 1988 has been filed by the appellant / claimant, impugning the judgment and award dated 27/10/2025, passed by the Motor Accident Claims Tribunal Shri Bhumi in MSC case number 83/2020. The appellant is mainly aggrieved with the quantum of compensation awarded to him by the impugned judgment. Stop. I have gone through the grounds stated in the memo of appeal and have considered the submissions made by learned counsel for the appellant. This appeal is admitted. Let the records of MEC case number 83/2020 be called for from the concerned tribunal. Let also notice be issued to the respondents. The appellant shall take steps for issuance of notice by speed post as well as by usual mode within 7 days from the date of this order, returnable on 22nd of May.
Item 6, orders.
My please, your lordship.
See to all of you.
My lord, in this appeal, the respondent number 1, my lord, died. And accordingly, my lord, I have filed 3 IA. One is for condonation of delay, other is for substitution of legal aid, and for setting aside of abatement.
I believe them.
That, my lord, that has not been brought in record, my lord. I think it is not available.
Oh, it is not.
My lord, why? My lord, filed on 26/2/2024, serial number, my lord,
24.
my lord,
It is still not there in record.
no money.
Oh,
My
Why?
lord, serial number is. that-
My friends, my lord, all those applications in every case are defective, my lord. In another matter, his case, my lord, 6-7 years last, my lord, he is not rectifying another similar petition. my lord.
No, that should
Yes,
not be,
yes.
that should not be.
No, yes,
No.
this is
Not be
relevant,
submission.
relevant, yes,
Maybe.
that
It is
is
also-
irrelevant submission.
yes, my lord.
That
In
should
this
not-
case also, my lord, long back, my lord, I give the particulars, my lord. Still, my lord, it is not reported and.
You have the filing numbers.
Yes, ma'am. Filing number, my lord, so far as the
Heard Mr. T.U. Loskar, learned counsel for the appellants. Also heard Mr. A.M. Barbuya, appearing for whom?
My lord, my client is expired.
Uh, Appearing for respondent number?
One, my lord, who is
Respondent number 1 who has expired. Learned counsel for the appellant has submitted that he has filed 3 interlocutory applications, namely one for setting aside the abatement of the appeal on death of respondent number 1, one for condonation of delay in filing the said application, and lastly for substitution of the legal heirs of deceased respondent number 1. He submits that the aforesaid applications were given filing number, namely
2454
likho Abhishek 2454
slash 2024,
comma
2455 and 2456. Respectively,
2024.
2024.
However, it appears that said interlocutory applications are not yet placed along with this appeal. The registry is directed to list the aforementioned interlocutory application with this appeal on the next date fixed. Let this case be listed again on 8th of May.
Grateful.
Item
Develop.
7.
May it please your lordship. In this case, on earlier occasion also, we have prayed that we have filed our dusty affidavit, but it was not on record. Today also it was not on record.
Not all, you have not filed.
We have filed, but maybe lordship, it was on defect, under defect, I think. We may be allowed to clear our defect if any.
Okay. What is in defect?
Lordship, I have to go to filing section to see what defect they have found.
No, the office note says that you have not even filed the affidavit.
Lordship, we have given to our clerk on 9/3 for filing the affidavit.
But he has not filed.
Maybe lordship.
He
Today I pray for little accommodation, Lord.
heard Miss S. Mushahari, learned counsel for the appellant. Also heard Mr.
R.S. Chauhan.
H.
R.S. Chauhan.
R.S. Chaudhary, appearing for respondent number
126.
1 to 6. Does the service in respect of which respondent? Learned counsel for the appellant prays for some time for filing affidavit in compliance regarding service of notice by way of dusty mode on respondent number 7. The prayer is allowed. The appellant shall file the affidavit in compliance before the next date fixed. Let this matter be 29th of May.
Highly honorable.
Item 8. Item number 8.
None has appeared for the petitioner on call. On perusal of the petitioner on call, stop. It appears that in the cause list, name of two counsels have been shown as engaged counsel for the applicant/review petitioners. Let this matter be listed again
29.
on 29th of April.
Item 9.
Please, Your Lordship, my lord, I have filed the affidavit regarding justice service, my lord.
On respondent
Respondent
number
number 1, but nobody appeared, my lord. And the matter pertains to, my lord, withdrawal of some amount which was already deposited before the honorable court, my lord, 50%. The case is disposed, my lord, on my lord local adalat, but remaining amount already paid, my lord. But 5,34,800, my lord, which has already deposited in that honorable has not, my lord, released.
heard Mr. K.R. Patgiri, learned counsel for the applicant. Office note dated. And other respondents?
My lord, other restaurant, my lord, is a owner driver, my lord. It's not a necessary party, my lord, because my lord already settled, my lord.
On perusal of the office note dated, on perusal of the records, it appears that the applicant has filed an affidavit in compliance regarding service of notice by way of Dasti mode on the respondent number 1, that is Oriental Insurance Company Limited. On perusal of the copy of notice annexed along with the affidavit, it appears that it bears seal and an illegible signature and seal of the respondent number 1 company. In view of the affidavit, in view of the said affidavit, the notice upon respondent number 1 is held to be duly served. Since the connected MSC case, connected MSC appeal has, where is the order of the Lok Adalat?
Lord, kindly say page 30, my lord, 30.
MSC appeal has already been disposed of
11/9/2021.
by order dated 11/9/2021, passed in a MSC appeal number 411/2019. Notice to other respondents are hereby waived. This interlocutory application has been filed by the claimant / applicant praying for allowing her to withdraw this is 50%.
50%, my lord.
50% of the awarded amount, that is rupees 5,34,800, which was deposited by the
Insurance company.
insurance company before before the registry of this court on 21/8/2019 in pursuant to the orders passed in IA Civil number 2632/2019 on 7/8/2019. Why so much delay in?
My lord, remaining amount, my lord,
No,
already-
why you have approached this court so delayedly? It was filed in 2019
19, my lord.
and you have filed this IA in 2020.
2022, my lord. My lord, my lord, remaining amount, my lord, kindly see page 32. Paid by the, my lord, learned member of the on, my lord, by check number 27 in the year 2022, my lord. Page 32.
Remaining amount you have received.
Remaining amount already received, my lord. From the learned, my lord, member. The alia engaged counsel has not informed the claimant, my lord, regarding deposition of 50% amount before this honorable court, madam. Never informed, my lord.
It appears that the connected appeal was amicably settled between the parties, that is the present applicant and the insurance company. And an order to that effect was passed by a coordinate bench of this court on 11/9/2021 in MSC appeal number 411/2019, whereby the insurance company was directed to deposit the balance amount of rupees 5,15,200. Why this discrepancy?
5,15,200,
200
my lord.
before the registry of this court. And it also, and by the same said order, it was also directed that same would be released to the claimant by the registry after proper verification.
Deposited amount of, my lord, 5,34,800. And remaining amount already paid, my lord, 5,15,200.
No. You see it, page 30.
33
Page 30 says that 534 has already been paid.
already paid by the, my lord, insurance company before this, my lord, registry, my lord. And next paragraph, my lord, kindly see, my lord. In view of the appeal stand closed with a direction that insurance company shall now deposit the balance amount 5,15,200 being full and final settled, and this amount, my lord, paid by the learned member, Nogao, my lord, kindly see page 32, my lord, I check.
Okay, that amount you have received.
Received, my lord, 5,15,200, but remaining amount, my lord, pending before this honorable court, my lord. 5,34,800.
No, but paragraph, no, this paragraph number 4 says that it has already been paid to you.
Paid,
It's-
my lord, it is, my lord, wrong submission, my lord, but it is paid by the insurance company before this.
How we will come to know that it has not been paid to you? Because the order says that
I have stated paragraph number 5, my lord. Said amount, my lord, deposited before the honorable court on 21/8/2019.
Where?
Paragraph number 5, my lord, of my application,
No, that is your
my
application.
lord.
But this has to be verified.
My lord, the record is available, my lord.
Is there any endorsement in the record?
But
You check the record. If
Well-
there is any endorsement regarding deposit,
my lord,
we'll order it. We'll take it up as next item. यहाँ तक रोक दो. Next. We will take it up as next item. You verify from record.
my lord.
Huh? एकेटा record আছে ন? Main কেছত থাকিব পাৰে. এইটো চাব দিয়ক.
Item 10.
May I please, your lordship? Lordship, in this case, LCR received lordship and notice has been served lordship.
It is ready for hearing.
No lordship, today not. Matter may become hearing for after Bihu vacation lordship.
Heard Miss, what is
But
your
they appearing on behalf of.
heard
mayor,
Miss are the learned counsel for the appellant? Where is this service report?
Please not do that lordship.
You go through the record and find out, because the note may be wrong, office note may be wrong. Service report may be there in the record. You check the record and flag the service report. Savadhu.
Item 11 and 12.
Ranjan Sharma report. Ranjan Sharma full report. Yes.
My lord, the appellant already deposited the awarded amount. In the last occasion, your lordship has 50% left. Now, I filed the application for 50%, for release of the 50% awarded amount.
No, what is the status of the appeal?
No, but appeal is already that amount.
LCR also received.
Okay, appeal is ready for hearing.
No, because regarding service of respondent number 2 and 3, lordship, in one case, lordship, ID card has not returned. And another cases, lordship, it has returned unserved, lordship. So in both cases, I want to take step by substituting service by paper publication.
Both are connected cases.
Yes, yes, lordship, respondent number 2 and 3 is same, connected case.
And which appeal is filed by insurance company?
It's been
Both.
Both the appeal filed.
both appeal. Analogous case, lordship. Arising out.
The claimants are different.
Payments are
Claimants are
different.
different, but
They already expired, my lord, out of the accident.
Okay. In 11 and 12, MEC appeal common order. Heard Mr. Heard Mr. K.K. Bhatto, learned counsel for the appellant. Also heard Mr. I.A. Talukdar, learned counsel for respondent number 1. It appears that notice issued to respondent number 2 and 3 have not yet been served. Learned counsel for the appellant prays for allowing the appellant to take fresh steps for issuance of notice upon the aforesaid respondents. The prayer is allowed. The appellant shall take fresh steps for issuance of notice upon respondent number 2 and 3 by speed post, as well as by usual mode within 7 days from the date of this order, returnable on 29th May. You have filed any IA for withdrawal?
I want to take step in both cases, let's say a common order is necessary, let's say, so that I can testify, one paper or two paper, let's say, in both cases, let's say.
No, common order,
Common order for the both case, let's say.
both cases, yes, common order in both cases. I passed common order in both cases. You have filed any IA for withdrawal?
Yes, I filed respondent number. In both the cases filed, my lord. For release of 50%, 60%.
The 621 is for
For release of 60%, my lord. Yeah. And another is 399 for release of 50%, my lord.
621, IA 621 will keep up. Heard Mr. IA Talukdar, learned counsel for the claimant slash applicant. Applicant slash claimant. Also heard Mr. KK Bhatto, learned counsel for the insurance company, New India Insurance Company. This application, this interlocutory application has been filed by the applicant, praying for allowing the applicant to withdraw the 60%. 60% was deposited.
50% was deposited. 50%, if 50% is no problem, my lord.
Then why you have mentioned 60%?
But some more need is required, so that is why 60%.
No, but when they have not deposited, how you can withdraw?
Then 50% deposit. Yes, yes. Oh, then 50%, my lord, no problem. After my application, they have deposited, my lord.
Withdraw 50% of the awarded amount, which was deposited by the
Before the registry of the
insurance company before the registry of this court, in pursuant to the by which order they have deposited.
my lord, on the last 2024.
By order dated
2012-2024.
2012-2024. In IA number
I number, let's say, 3995
3995
of 2024.
/ 2024. Learned counsel for the respond. Insurance company does not opposes the prayer. Hence the prayer is allowed. The registry shall disburse the 50% of the awarded amount deposited by the insurance company before it, in pursuant to the aforesaid order, to the applicant slash claimant after claimants after proper verification. This IA is accordingly disposed of. Then IA number 399. This application, same parties, AR Talukdar and KK Bhatto.
Aye, Talukdar.
Sorry, IA Talukdar and KK Bhatto. This interlocutory application has been filed by the claimants. Filed by the applicant slash claimant, praying for release of 50% of the awarded amount deposited by the insurance company in pursuant to the directions. Which was the order in 399?
In second case, let's say, IC number 3164/2024, order dated 21/10/2024.
order dated 21/10/2024. Second case means
Second case is in
MAC
order.
appeal 537.
537. 537.
Yes, what is the date of order?
Date of order 21/10/2024.
Order dated 21/10/2024. In 2024,
Yes, Lordship.
24 in IA number
3164/2024.
316
3164.
4 of 2024.
21, 22.
The
3164/2024.
learned counsel for the insurance company does not oppose the payer, hence the prayer is allowed. The registry is directed to disburse the aforesaid amount to the applicant/claimant after proper verification. This interlocutory application is accordingly disposed of.
Item 9.
Abhishek Kumar. You have seen?
My lord, I have seen, my lord, I have given flag mark, my lord. Already deposited and the regarding
Item 9 में last पैरा क्या था? No, 5 lakh
34.
5.
Petitioner.
5 lakh 34. 5,34,800 only before the registry of this court. It appears from record that in pursuant to the aforesaid order, order dated 7/8/2019 passed by this court in IA civil number 2632/2019 in connection with MSC appeal number 411/2019. The aforesaid amount of rupees 5,34,800 has already been deposited by the insurance company before the registry of this court on 26/8/2019. Stop. Accordingly, since the claimant is entitled, how many claimants are there?
One, my lord.
Claimant is entitled to get the aforesaid amount. The registry is directed to disburse the said amount to the claimant/applicant after proper verification. This interlocutory application is accordingly disposed of.
My lord.
Where is the interlocutory application? This interlocutory 1870 is accordingly disposed of.
All right.
Item 10.
Have you found out?
No, Lordship, 12/6/2024 stay will be taken, but not in the record, Lordship. Kindly issue fresh stay. Lordship.
It has, because I doubted the concerned assistant used to give wrong reports. Though he has mentioned that it has been served, but there is nothing in the record.
In the record, Lordship.
So you have to take fresh steps. Heard Miss
Dev, Lordship.
R.
Dev.
Are they learned counsel for the appellant? Though on perusal of office note dated 16/6/2025, it appears that it has been mentioned that notice to respondent has been served. However, nothing is there on record on the basis of which said conclusion has been arrived by the registry. Hence, the appellant is directed to take fresh steps for issuance of notice upon sole respondent.
Yes, Lordship.
Sole respondent by speed post as well as by usual mode within 7 days from the date of this order, returnable on 29th of May.
Obliged, Lordship.
Item 13.
My lordship, my lord. There is a condition of delay between lordship in filing RFA. The delay for 334 days, your lordship. So, your lordship, delay may can be condoned and the case be proceeded on merit, your lordship.
The notice you are appearing for
Respondent number 1 and 2.
both. You are opposing.
No,
Heard Mr. A. Diwan, learned counsel for the applicant. Also heard Miss
S. Pal.
S. Paul, learned counsel for the respondents. This application under Section 5 of the Limitation Act has been filed by the applicant. Filed by the applicant, praying for condonation of delay of 344 days in filing the connected appeal whereby the judgment and decree dated 22/12/2022 passed by the Court of Learned Civil Judge Bongaigaon in title suit number 94/2018 has been impugned. Learned counsel for the applicant has submitted that the applicant has stated the reasons for delay in preferring the connected appeal in paragraph number
Paragraph number 4, as well as your lordship, 4, 5.
4 and 5 of the instant interlocutory application. Learned counsel for the respondent has, considering the grounds stated in the interlocutory application, not opposed to the prayer for condonation of delay. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the records. Considering the grounds stated in paragraph number
6 also may kindly, 4, 5 and 6.
4, 5 and 6 of the instant interlocutory application to be sufficient cause which prevented the appellant in approaching this court by filing the connected appeal within prescribed period of limitation, the delay of 344 days in preferring the connected regular first appeal thereby condoned when this interlocutory application is allowed. The registry is directed to register the connected RFA and list the same for admission after a week on a date to be fixed by registry.
Item 14.
See. Well, my learned pen has appeared on for the respondent number 1, my lord, but kindly peruse the order dated 14/8/2025. Inadvertently, notice was not issued in that by that order. So we could not take steps upon respondent number 2.
Okay. Heard Mr. A. Roy, learned counsel for the appellant. Also heard Mr.
N. Kalita, Lordship.
N. Kolita, appearing for respondent number 1.
On behalf of Lordship, A. Ali, Lordship.
It appears that notice to respondent number 2 has not yet been issued. Issue notice to respondent number 2. The appellant shall take steps for issuance of notice upon respondent. How many respondents are there? 2. Respondent number 2 by speed post as well as by usual mode within 7 days from the date of this order, returnable on 29th of May. List accordingly.
Lordship, may I pray for date, Lordship, as similar matters are,
29th May.
no, Lordship, similar matters are already
Similar,
fixed,
those matters, my lord, notice has been issued, we have taken steps, awaited.
What is your prayer?
for 30 April, Lordship.
We are fixing on 29th of
May.
May. Let it be.
Always.
Interim order is there, that may be.
What interim order?
My lord, further proceeding was stayed on by
The
order.
interim order granted earlier shall continue till next date.
I'm authorized.
Nice.
Item 15.
Lordship, pass over the matter for time being, Lord.
What is the matter?
Lordship, this is for service report. I am appearing for respondent number 2, Lordship, the insurance company. And we are supposed to take steps on respondent number 1, Lordship. There's the owner come driver. This is the McAfee, Lordship.
Okay, they have taken steps.
Yes, Lord.
Heard, Mr. What is your name?
A.R. Mondal,
A.R.
Mondal,
Mondal,
on behalf of SSL.
learned counsel for the appellant. Also heard Mr. P.M. Talukdar, appearing for respondent number 2. It appears from office note dated 26/3/2026 that the notice issued to respondent number 2 has not yet returned. Stop. The registry is directed to place the postal track consignment report of notice sent to respondent number 1 by speed post, before this court on the next date fixed. The registry shall also issue reminder for the records of the concerned MSC case from the concerned tribunal. Let this matter be listed again on 22nd of May.
Item 16.
May it please the Lordship. Lordship, LCR is awaited in this case. Otherwise, service is complete.
Heard Ms. M. Soikia, learned counsel for the appellant. On perusal of the office note dated 31/3/2026, it appears that the records of MSC case number 2393/2019 has not yet been received by the registry. Stop. Let a reminder be issued for the aforesaid records. Registry to take steps. Let this matter be listed on 21st of May.
Item 17.
Lordship, in this case, name of the respondent number 2 and also my name is also not reflected in the cost list, Lordship. The respondent number 2, T. Kolita, is representing the insurance company, Lordship. Just. And LCA has been received, Lordship.
The appearance is complete.
Appearance of respondent number 1 is awaited, Lordship. No, 3 to. One. Only 1 is awaited, Lordship.
Heard Mr.
D. Sharma, Lordship.
D. Sharma, learned counsel for the appellant. Also heard Mr. S.I. Akan,
Respondent number 3.
appearing for respondent number 3. And what happened to 2?
His name is reflected in the order dated 19/11/2025, passed in the miss case filed by the petitioner along with this application, Lordship.
You have to issue fresh notice.
Lordship, he already entered appearance in the Lordship miss case.
You inform him.
Lordship, I will inform accordingly. But registry may be directed to Lordship reflect the name of My name and also the name of the respondent number.
The notice to respondent number 1 has not yet returned. Learned counsel for the appellant submits that Mr. T. Kolita is appearing for respondent number 2. However, his name has not been reflected in the cause list. Stop. Registry is directed to reflect the name of Mr. D. Sharma, learned counsel for the appellant, as well as name of Mr. T. Kalita, learned counsel for respondent number 2,
Lordship, my name has been not also reflected in the.
as well as Mr. S.I. Akan, learned counsel for respondent number 3 in the cause list henceforth. The registry shall also place the track consignment report of the notice issued to respondent number 1 by speed post before this court on the next date fixed. Let this matter be listed on 18th of May.
Item 18.
Please, your lordship. Proceed.
Mr. Kalita, you are appearing in the earlier case.
No, my lord. My item number is 18, my lord.
Mato.
My lord.
No, in 17, a submission was made that you have appeared for respondent number 2. Which T. Kalita? This one?
This one, my.
T. Kalita. His name is reflected in the order dated 19/11/2025.
You verify whether you are appearing or not.
T. Kalita name is reflected.
T or D?
T for telecom. T. Kalita name.
Respondent number.
Mr. Kalita, you verify from the earlier.
Number 2 নাম আগৰ নিষ্কাশত এপিয়াৰ কৰিছে কি নাম হয় টি কলিতা Lordship, this is T Kolita, not D Kolita. For respondent number 2.
D. Sharma, Lordship. My name is D. Sharma, Lordship. For the appellant.
I will verify, my lord.
Later on, you verify in the early. Okay. Yes.
My lord, as per the office note, my lord, 3326, my lord. Notice not, service is not complete, my lord.
None has appeared, no? Heard Mr. T. Kolita, learned counsel for the appellant. Also peruse the office note dated 33/2026, which shows that service report in respect of notices issued to respondents have not yet received. The registry is directed to place the postal track consignment reports of notices sent to respondent number 1 to 3 by speed post before this court on the next date fixed. Let this matter be listed
TCR may be called for, my lord. TCR. will be
on
given.
21/5. Let the records of MSC case number. Let a reminder be issued for calling for the records of MSC case number 379/21 from the concerned tribunal.
High level.
Beleg. No, let him verify. You verify from there.
Item 19.
Yes, Mr.
IA has been filed, my lord. I have not, I just appeared, my lord. I have not gone through the record, my lord. But we have already taken steps, my lord.
On respondent number 1, it is served.
Well, other respondent, my lord. Maybe, my lord, strike up, my lord.
No,
The other-
we'll ask for postal track consignment report. You have taken steps. Heard Mr. S. Ahmed, learned counsel for the applicant. On perusal of the office note dated 30/3/2026, it appears that notice to respondent number 1 has been duly served. The same is therefore held to be duly served on respondent number 1. As regards other respondents, the service report is awaited. The registry is directed to place postal track consignment report of notices sent to respondent number 2 and 3 by speed post before this court on the next date fixed. Let this matter be listed on 18th of May.
Obliged, my lord. Much.
Item 20.
My lord, in this case, there is 59 days delay in filing the appeal. Respondent number 1 to 3 has appeared.
You are opposing, Mr. Chakravarti?
Lordship. It's not 59, Lordship, as per his own application, Lordship, it is
More.
244 days.
So you'll be filing some objection.
Relying on your Lordship judgment, one Lord.
You'll be filing an objection.
Filed, we have already filed, Lordship.
Okay. Kohima bench.
Kohima bench, Lordship. 11 paragraph 13, Lordship.
How much was the delay in that case?
330 days. On administrative procedure, Lordship has explained what should be.
Yes, Mr. Bhattu.
Actually, I have explained it from para number 5 to 8.
Where is your objection?
Lordship. Likely to be in the record, Lordship, because we have filed long back.
You have gone through this judgment, Mr. Bhattu. Go through it. Let him go through it. Give the reference to him. We'll take it up on some other day.
Lordship.
Heard Mr. K.K. Bhattu, learned counsel for the applicant. Also heard Mr. B. Chakravarti, learned counsel appearing for respondent number 1, 2, and 3. The learned counsel for the applicant seeks some time to go through the ruling cited by learned counsel for the applicant, learned counsel for the respondent, before he makes his submission in this case. The prayer is allowed. Let this matter be listed on. No. April or Bihur Pisodhyam. 29th of April.
May I beg to interrupt, Lordship? May I beg to interrupt?
You are appearing.
Yes, my lord.
Okay.
My name is not there, that is why, my lord.
Okay.
I'm
No,
sorry.
I have directed to reflect your
I'm
name.
sorry, my lord.
Item 21.
Oh, 21, you prayed
Yes,
for
yes,
an
yes,
adjournment.
My lord, last time your lordship directed to take press step by speed post, my lord. My lord, I'm sorry that due to some,
You take now.
yes.
We
my
are
lord.
giving you time.
Yes, my lord.
Heard Miss B.R.A. Sultana, learned counsel for the applicant, who submits that due to some communication gap, the applicant could not take steps for issuance of notice as was directed by this court. She seeks some more time for taking steps for issuance of notice by speed post on the respondent. How many respondents are there?
My lord.
On the
only
sole
some
respondent. Within 7 days from the date of this order, returnable on 21 May, list according.
Item 22.
Lordship, please pass the matter for timing. Senior counsel is in court number 10.
What is the matter?
The condonation of delay of 47 days in preferring the MSc appeal.
You will be opposing.
We have no objection.
Who will be coming? Who is your senior?
Mr. M. Dotto.
Okay, we'll take it up after some time. Let him come.
Item 23.
Yes,
Your lordship, records have been received. Lordship may fix the matter for hearing.
the appearance is complete. Who is appearing for the
Your lordship.
heard Miss
You be honey.
U. Bihani, learned counsel for the
Feeling.
appellant. Also heard Miss
It's a voice. Lordship.
H.
It's a boy.
H. Opoy, learned counsel for whom you are appearing.
GPEGO, CGC.
Learned counsel appearing on behalf of Mr. G. Pego, learned central government counsel appearing for respondent. The office note indicates that the records of original application from the Railway Claims Tribunal has been received, and therefore this appeal is ready for hearing. List this matter for hearing on 25th of June.
My lord, similar order may be passed in item number 24, 25, and 26. And also item number 48 of supplementary list, lordship.
24, 25,
26.
26, Mr. C.K.S. Borua will be for the other side.
Item number 24. on
24.
H. Gupta.
24 order eke hobo. What is your name?
E.R. Chaudhary.
P.R. Chaudhary for respondent. 25 C.K.S. Borua for respondent. And 40
48. lordship.
48 who?
Supplementary list.
Who is appearing for respondent? Mr. Borua.
Number
48.
48, no, I am not appearing.
48 will pass order later on.
I am appearing item 26, not 25.
Yes, 26. Same order. 48 will pass orders when matter is called. You have to wait.
Much order.
No, sir.
Dates, you take the dates from the court master at the day. The date low. I am taking it.
Item 22.
Yes.
There is a delay of 47 days in preparing the appeal.
So I am for the respondent number 1. I have no objection now.
Heard Mr. A. Bhattacharya, learned counsel for the applicant. Also heard Mr. M. Datta, learned counsel for respondent number 1.
DJ Bora Lordship, respondent number 3.
Also heard Mr. D.J. Bora, D.J. Boro, appearing for respondent number 3. Do you have any objection? Stop. This interlocutory application has been filed by the applicant insurance company, praying under Section 5 of the Limitation Act 1963, praying for condonation of delay of 47 days in filing the connected MAC appeal. Stop. The appeal is for enhancement.
No, by the insurance company.
Okay, but regarding quantum or
Yes, madam.
quantum only or liability also?
Quantum only, madam.
Quantum. Since the connected appeal has been filed by the present applicant insurance company, on being aggrieved with the quantum of compensation granted to the claimant, and since the learned counsel for the claimant has conceded to the prayer for condonation of delay made by the applicant, notice to respondent number 2 is hereby waived. I have gone through the grounds stated in paragraph number
3 to 6.
3 to 6 of the instant interlocutory application. Same appears to be sufficient cause which prevented the applicant in approaching this court by filing the connected appeal within the prescribed period of limitation, hence the delay of 47 days in filing the connected MAC appeal is hereby condoned, and this interlocutory application is allowed. The registry is directed to list the connected MAC appeal and registry is directed to register the connected MAC appeal and list the same for admission on the next date fixed, on a date fixed by it after a week.
Our name may be.
The name of Mr. M. Datta as well as Mr. DJ Boro may be reflected as learned counsel for respondent number 1 and 3 respectively.
The copy, yes, no, that copy may directly.
On next date you file, before next date you furnish the
sir.
copy of memo of appeal.
Item 27.
May I please your lordship, as per official ticket 31-3 LCR is not received by your lordship.
The appearance is complete.
Yes, lordship. All are government lordship. 1 to 4.
This is item number
27.
27. Heard Mr. What is your name? P. Sharma,
P. Sharma.
learned counsel for the appellant. Also heard Mr. T. Borwa, C. Borwa,
For respondent 1.
learned counsel appearing for respondent number 1. Mr. A. Bhattacharya appearing for respondent number 2. And Miss N. N. Burman. Sorry. Miss D. D. Burman, learned senior additional government counsel appearing for respondent number 3 and 4. It appears that the appearance of parties in this case is complete. However, the records of the trial court have not yet been received by the registry. The registry shall issue reminder for the same. List this matter after receipt of the trial court records for hearing on 14th of July.
Yes. Yes, my lord. Our name is, my name also to be recorded.
Name of Mr. C. Borwa as you are appearing as
Standing counsel.
standing counsel.
NHIDCL.
NHIDCL, maybe NHIDCL, and name of Mr. A. Bhattacharya as standing counsel Revenue Department may be reflected in the cause list henceforth.
Item 29.
May it please your lordship. Lordship, this is an application for withdrawal of the 50% of the awarded amount deposit before the registry by the appellant.
Any objection? Heard Mr. N. Datta, learned counsel for the applicant / claimant. Also heard Mr. A. Bhattacharya. learned counsel for the
Insurance company.
respondent insurance company. This application has been filed by the applicant slash claimants praying for withdrawal of 50% of the awarded amount which was deposited by the insurance company before the registry of this court in pursuant to the directions of this court by its order dated 13/8/2025 in IA number 2573/2025 in connection with MSC appeal number 342/2025. The learned counsel for the insurance company has no objection to the prayer, hence the prayer is allowed. The registry shall disburse the 50% of the awarded amount deposited before it by the insurance company in person to the aforesaid orders to the applicant slash claimants. How many claimants?
One.
Applicant slash claimant after proper verification. This interlocutory application is accordingly disposed of.
The main appeal, my lord, as per office note dated 27/3/2026, service is complete and LCR also received.
Main appeal. Again, heard Mr. A. Bhattacharya, learned counsel for the appellant. Also heard Mr. M. Dr. learned counsel for respondent number 1. It appears on perusal of the office note that notice issued to respondent number 2 and 3 have been duly served. It also appears that records of concerned MSC case number 1578/2021 has also been received. Hence, this appeal is ready for hearing. Release this appeal for hearing on
16th of July.
16th of July.
Highly obliged.
Obliged.
Item 30.
May it please your lordship. Lordship, this I is for stay of the judgment, lordship. Actually, our appeal was already admitted. Inadvertently, this I was not filed at that point of time. Our appeal is based on the ground that in other case, there were 2 vehicles involved. And in other case, the liability was fixed on the totally on the other vehicle. So that is our ground of appeal, lordship. But lordship, at this point of time, we can deposit 25%. That is 50, even if ultimately the court comes to a finding that 50-50 or something like that, lordship, of both the vehicle, then also there will be
Entire liability has been
lesson on us. So, lordship, 25% we can deposit, lordship, and they can withdraw.
My lord, I may be allowed to withdraw and they may be directed to deposit 50% because my lord, before the tribunal, my lord, there was no such evidence laid in that effect to come to a conclusion that
It was head-on collision that was proved.
Only
That
my
was
lord
proved by
head-on
claimant
collision.
themselves, and in other case the liability. So
No evidence, my
at
lord.
this point of time we can deposit 25% and they can withdraw it,
no, you deposit 50%.
and they can withdraw 25.
No, let them withdraw because your
injury case.
as per your case also, maximum liability may be imposed up to the extent of 50%.
There are quantum also, lordship. Grounds are on quantum also because, lordship, this is a injury case and the court has said 25% disability without any evidence, lordship.
Much 25%.
25% disability,
It's a
lordship.
permanent injury case.
What was the
We
injury?
have also filed
No,
cross
no, it
objection.
is not a question of permanent injury. They have to prove disability. 2,70,000 was given on that ground itself, lordship. On that point, that is 4 in the judgment. Disability 25%, 2,70,000, lordship. And we are also
What
challenging
was the injury?
injury, lordship. pelvis, she had NCRT report attainment of pelvis and hip joint. The X-ray reports are there, Lordship.
Okay, heard Miss R.D. Majumdar, learned counsel for the applicant / appellant. Also heard Mr. M. Datta, learned counsel for respondent number.
Is it party
Respondent
number 1, I suppose?
One, my lord.
1 / claimant. Yes, opposite party number 1 / claimant. This application, this interlocutory application has been filed by the applicant, praying for condonation of,
No, my lord.
sorry,
Stay.
playing for stay of the execution of judgment and award dated 8/8/2022, passed by the Motor Accident Claims Tribunal, Golaghat, in MAC case number 101/2017, during the pendency of the connected MAC appeal number 85/2024. Learned counsel for the applicant has submitted that the applicant has impugned the connected appeal, impugned the aforesaid judgment and award in the connected appeal. The said appeal has already been admitted by this court. She further submits that in some other cases arising out of same accident, the liability of payment, paying the compensation, has been fixed on the another insurance company, that is United India Insurance Company Limited. She further submits that in the connected appeal, she further submits that in the since the accident occurred due to head-on collision between two vehicles, there is every possibility in the connected appeal that liability to pay compensation by the present applicant may be decreased to the extent of less than 50%. She therefore submits that if this court intends to impose a condition for grant of stay, the insurance company applicant is ready to deposit 50% of the awarded amount, 25% of the awarded amount. She further submits that in the connected appeal, the applicant has also questioned the quantum of the compensation awarded to the respondent claimant. Stop. On the other hand, learned counsel for the respondent number 1 / claimant submits that he does not have any objection to the aforesaid prayer and to the prayer for stay of the execution of the impugned judgment and award if the insurance company deposit 50% of the awarded amount as a condition of stay of execution of the impugned judgment and award. Stop. Since the respondent number 1 has conditionally conceded to the prayer of the applicant, Notice to other respondents is waived. Other respondents is waived. I have considered the submissions made by learned counsel for both sides. After considering the materials on record, including the memo of appeal of the connected appeal filed by the applicant, this court is of the considered opinion that the interest of justice would be served if the prayer for stay during the pendency of the connected MAC appeal within bracket MAC appeal number 85/2024 is allowed. However, same is subject to payment of 50% of the awarded amount by the applicant insurance company.
We may be directed to release them.
Accordingly, the judgment and award dated 8/8/2022 passed in MEC case number 101/2017 by the Motor Accident Claims Tribunal Golaghat is hereby stayed, subject to deposit of 50% of the awarded amount by the insurance company applicant before the registry of this court within a period of, see, how much time?
6 weeks.
6 weeks from the date of this order. In the event of deposit of such amount by the insurance company, same shall be disbursed to the applicant, to the claimant / respondent number 1 after proper verification by the registry, subject to submission of an indemnity bond, that in the event the appellant is found to be liable to pay a lesser amount than that of 50% of the awarded amount, the remaining amount shall be deposited back by the shall be refunded by the claimant.
To the insurance company.
Yes, to the insurance company. This interlocutory application is accordingly disposed of.
Lordship, in the appeal, Lordship, the LCR is received, but for AD card for 2 and 3 not received back. So tracking report may be called from registry, Lordship. Otherwise, it will be ready for hearing.
Heard Ms. R.D. Majumdar, learned counsel for the appellant. Also heard Mr. M. Datta, learned counsel for the respondent number 1. No, track report will not come because you have taken steps in the year 2024.
Yes, Lordship. Then, Lordship, it can be deemed served that way because AD card is not received. And moreover, it is basically on quantum, not on policy.
For deemed service also, that postal receipt is necessary.
We have to await, Lordship. Let us await.
Then
But if we await, nothing will come.
So let's see, Lordship. Lajima also, that can be done.
No, what Lavajima will do?
Yes, if track report is not there, then it will not be possible.
You have to take fresh steps.
Lordship, let's wait. Because too
No,
many steps are
waiting.
coming. Lordship, too many steps are coming in my chamber and we are.
No, we'll give a longer date.
Okay. 1 month, Lordship, maybe.
Okay. 15 days time.
I can strike them off, Lordship. That will be better. Because it is only on quantum. No policy, nothing. No, it is unlike other cases of mine. This is on. It's strike off.
Last line. Last line. Okay. On perusal of the office note, it appears that Notice issued to respondent number 2 and 3 has not yet received back, not yet returned. Learned counsel for the appellant submits that since the appellant has no, you are also challenging liability to the extent of more than 50%.
That is United is there, Lordship. Insurance company is there.
Who is appearing for?
Someone was appearing.
Limited, I think someone was appearing earlier.
Earlier, someone was appearing. I do not have the main file.
Cause list. Let me check the cause list. My lord. There, so definitely their name will be reflected.
No. There is no indication.
Okay. Then Lordship, I think we have to take, I have to take it.
You can take upon the United only.
United is. United is 4, Lordship.
For FN
Four, I
Jaman,
think.
MS FN Jaman, and S Mrs. S Roy for R4.
That is Sanchita Roy, Lordship.
Which order?
No, my
No,
lord,
it
in
is the
the,
cause
in the
list.
cause list, my lord.
Okay. It appears that name of Miss S. Roy and Miss F. N. Jaman has been reflected as engaged counsel for respondent number 4. So, learned counsel for the appellant has submitted that notice to respondent number 2 and 3 may be waived as the grievance of the appellant in this appeal is regarding quantum of compensation which the appellant is liable to pay, for which the presence of respondent number 1 and respondent number 4 would be sufficient. Hence, she prays for waiving the notice to respondent number 2 and 3. The prayer is allowed. Notice to aforementioned respondents is hereby waived. The records of MAC case number 101/2017 has already been received. Hence, this appeal may be listed for hearing on the next date. List accordingly on 16th of July.
July.
My lord, I have filed one IA, my lord. My lord, I have preferred one cross objection in this MSc appeal, my lord. And in filing the cross appeal, my lord, 5 days delay was there.
You are opposing.
Lordship, that 5 days delay, I'll oppose the cross objection.
No, that will be in filing this 5 days.
5 days delay, I don't think I'll be opposing Lordship cross objection.
And I number 2381.
Yes.
Heard Mr. M. Dr. Learned counsel for the appellant. Learned counsel for the applicant. Also heard Ms. R. D. Majumdar, Learned counsel for the respondent. This application under Section 5 of the Limitation Act has been filed by the applicant /claimant, namely Manjula Kosari, praying for condoning the delay of 5 days in preferring the connected cross objection in MAC appeal number 85/2024 filed by the respondent number 1, New India Insurance Company Limited. Stop. Learned counsel for the Respondent number one, Ms. Hardy Mujumdar, considering the short period of delay, raises no objection against the,
Raised objection, but it is up to lordship.
though has objected to the prayer for condonation of delay, however, considering the grounds stated in the instant interlocutory application, this court is of opinion that the applicant was prevented by sufficient cause in approaching this court for filing the cross-examination, cross-objection within the prescribed period of limitation. Accordingly, the delay of 5 days in filing the connected cross-objection in MEC Appeal number 85/2024 is hereby condoned, and this interlocutory application is allowed. Registry is to register the connected cross-objection and list the same along with the MSc Appeal number 85/2024 on
16/7/20.
16/7/2020.
Highly obliged.
Obliged.
Item 41.
Yeah, please, Lordship, for preferring appeal, 40 days is delayed, my lord.
40 days.
In our
You-
petition, actually, it was cut out, so we were not able to say.
No, initially, my lord, I have written as 45 days or like this. So thereafter, some defective has come, I cured it. It is saying that from the registry.
Now, what is indicated in the copy given to the other side?
It's
No, I-
it was
I have-
actually not legible, Your Lordship. That's why.
40 days, 40 days.
That's why. I was-
Because it is erased.
But it is legible to you.
Eligibility in the court also, myself also here also, because that ink is not good. That is why, my lord.
So use good ink while making corrections.
40 days, it is.
Heard, yes, Mr. Mishra. Are you opposing?
Lordship may allow subject to payment of 50%.
No, first.
Of
thing
course.
is the-
Delay has to come.
We are okay with condoning the delay.
Okay.
40 days.
You are not opposing delay condonation application. Heard, Mr. R.C. Paul, learned counsel for the applicant. Also heard Mr. R.
A. Mishra
A.
on behalf of SDAS.
A. Mishra, appearing on behalf of Mr. S. Das, learned counsel for the claimant / opposite party. Number one. This interlocutory application has been filed by the applicant insurance company, that is New India Insurance Company Limited, praying for condonation of 40 days delay in preferring the connected appeal, wherein the judgment and award dated 6/11/2025 passed by the Motor Accident Claims Tribunal Dhumri in MEC case number 71/2020 within bracket D has been impugned. How many other opposite parties are there?
Well, there are two owner driver.
Learned counsel for the opposite party number 1/claimant has submitted that considering the short period of delay, the claimant / opposite party number 1 does not have any objection if the said delay is condoned. The appeal is for quantum.
My lord, appeal is quantum as well as my lord, there is a my lord, pattern collision also there.
Since the claimant has conceded to the prayer for condonation of delay, the notice to other respondents, other opposite parties are hereby waived. After considering the submissions made by learned counsel for both sides, and after going through the instant interlocutory application, this court is of the view that the cause shown in paragraph number
Without paragraph number. Four,
6,
4, 5 and 6.
4, 5, and 6 of this instant interlocutory application to be sufficient cause which prevented the applicant in filing the connected appeal within the prescribed period of limitation. Hence, the delay of 40 days in preferring the connected appeal is hereby condoned, and this interlocutory application is allowed. The registry to register the connected MAC appeal and list the same for admission after a week on a date to be fixed by it.
I'm furnishing the copy of memo.
List accordingly.
I'm showing the name in the appeal. Both.
Let the name of Mr. S. Das and Mr. A. Mishra be shown in the cause list as engaged counsel for the claimant respondent henceforth. Registry will give date.
There is combination of delay for 2 days, let's say.
Delay for
2 days.
2 days. But notice has to go. Or can we waive notice?
Some put, let's say, short days, delay, let's say.
Till how much period we can waive notice? That question will come.
Let's say.
So notice has to go. Heard Mr. K.K. Bhatta, learned counsel for the applicant. This interlocutory application has been filed by the applicant insurance company for condoning the delay of 2 days in preferring the connected appeal. Issue notice to the respondents. The applicant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 29th of May.
Item 43.
This is also a delay petition. Delay is of 57 days, Lordship.
Heard Ms. R.D. Majumdar, learned counsel for the applicant. This application under Section 5 of the Limitation Act has been filed by the Oriental Insurance Company Limited, praying for condonation of delay of 57 days in preferring the connected MAC appeal. Issue notice to the opposite parties. The applicant shall take steps for issuance of notice upon the opposite parties by speed post as well as by usual mode within 7 days from the date of this order, returnable on
Lordship, 10 days.
within 10 days from the date of this order, 29th of May.
Item 47 from supplementary list.
Yes.
So in this case, there is 80 days delay in filing time. Service is completed, delay may be condoned.
Actually, I have a formal objection, madam. Only my objection may be recorded. Otherwise, the delay may be condoned.
Mr. Chaudhary,
Chief, I have no objection.
heard Mr. K.K. Bhatta, learned counsel for the applicant, also Mr.
G Bhardwaj.
G. Bhardwaj, learned counsel for respondent number 5.
1 and 2.
Respondent number 1 and 2. Also Ms. M. Chaudhary, appearing for respondent number 5, as well as Mr. S. Chaudhary, appearing for respondent number 3 and 4. You have objection? This application under Section 5 of the Limitation Act has been filed by the New India Insurance Company Limited, praying for condoning the delay of 30 days,
80 days.
80 days in filing the connected appeal. Learned counsel for the respondent number 5 has opposed the,
Number 1 and 2.
sorry, learned counsel for respondent number 1 and 2 has opposed the oppose the prayer for condonation of delay, whereas learned counsel for respondent number 5 as well as learned counsel for respondent number 3 and 4 have no objection if the said delay is condoned. I have gone through the reasons stated in paragraph number
2 to 4.
2 to 4 of the instant interlocutory application, mentioned by the applicant for the cause of delay. This court is of considered opinion that said reasons may be regarded as sufficient cause which prevented the applicant in filing the connected appeal within the prescribed period of limitation. Accordingly, the delay of 80 days in preferring the connected appeal is hereby condoned, and this interlocutory application is allowed. The registry to register the connected MAC appeal.
See, the execution case has been pending, Lordship. It was fixed on 6 April, Lordship. So may I pay, Lordship? It may be fixed on 6 or 7, Lordship. Or
Connected appeal
Lordship,
on 6th of
6 of April, Lordship.
6th of April for admission.
Lordship, a copy of the memo of April.
Yes, yes, Lordship.
You serve the copy to all.
And our names may be reflected.
Names of Mr. G. Bhardwaj may be reflected as engaged counsel for respondent number 1. Name will be reflected. It is there in the, it is already
I will be.
admission. Okay. Names of Mr. G. Bhardwaj, name of Mr. G. Bhardwaj may be reflected in the cause list while listing the connected appeal for admission as engaged counsel for respondent number 1 and 2. Similarly, name of Ms. M. Chaudhary be reflected as engaged counsel for respondent number 5, and name of Mr. S. Chaudhary be reflected therein as engaged counsel for respondent number 3 and 4 henceforth.
Most of like.
Item 48.
May please your lordship. Records have been received.
Lordship, I'm for respondent number 1 to 3, Lordship. Some time may be granted so that we can file our affidavit, Lordship.
Records have arrived.
Yes, lordship.
Heard Miss A. U. Bihani. Bihani spelling is Bihani.
Yes.
Bihani, the learned counsel for the appellant. Also heard Miss
P. Rabha on behalf of Ms. A. Gayan.
E. Rabha, appearing on behalf of Miss A. Gayan, the learned central government counsel, appearing for respondent number 1, 2, 3. It appears that the records of original application from the Railway Claims Tribunal has been received. From where you are saying that records? From where you are saying that records have been received?
Lordship, in the previous date, records were called for.
Yes. Now whether it has been received or not,
Apologies, I forgot.
you have not checked. It has not yet been received. Records have not yet been received. Issue reminder for the same registry to take steps. Learned Counsel for respondent number 1, 2, and 3 has prayed for allowing the said respondent to file written objection against the contentions raised by the appellant in the memo of appeal. The prayer is allowed. The respondent may file their written objection before the next date fixed. Let this matter be listed 25th of May.
Hearing. Item 34 and 35.
I'm appellant in this two matter, 34 and 35, my lord. I have a prayer, my lord. I could not prepare the hearing, my lord, today, my lord. I have requested them also, my lord, but they have objected, my lord. To be honest, my lord. My lord, that is why, my lord, I'm praying, my lord, some accommodation, my lord, if possible.
Lordship, this is a very old matter. That's why, Lordship, otherwise the common judgment comprises of 4 cases, out of which, Lordship, in 4 cases, out of 4 cases, 2 cases payment were done, Lordship, made by them, Lordship. And in another 2 cases, they preferred this up to appeal, Lordship. MFA 31 and 33.
How much time will you take for
My lord,
preparation?
immediately after BU vacation, my lord, I'll do it. My lord.
We are giving a short date.
My lord,
A date may be fixed, Lordship.
sorry, sir.
April or Tilio.
Below dates wasn't provided.
India. 30 April.
30.
Heard Mr. UK Goswami. What is your
G
name?
Goswami, my lord.
Mr. G. Goswami, Learned Standing Counsel in the Railway. Also heard Miss
Sharma.
M. Sharma, Learned Counsel for the respondent. Learned Counsel for the
Full respondent.
sole respondent. Learned Counsel for the appellant submits that due to some difficulty he could not go through the brief and is not in a position to make submissions today before the court in this appeal. He seeks leave of this court for going through the fully preparing this appeal before he makes his submission. Though Ms. M. Sharma, Learned Counsel for the respondent, has objected to the prayer made by the Learned Counsel for the appellant on the ground that this is an old pending appeal of the year 2016, however, considering the submissions made by Learned Counsel for the appellant, the prayer is allowed. Let this matter be listed again on 30 April.
Obliged.
Yes, 39.
In this case, today I need some accommodation also. It will be taken in other details.
Yes, Mr. This. Heard Mr. K. Bhatto.
Short date.
K. Bhatto. K. Bhatto or K. Bhatto?
KK Bhatt.
Heard Mr. K. Bhatto. Learned Counsel for the appellant. Also heard Mr. H. Das, Learned Counsel for respondent number 1 and 2. Learned Counsel for the appellant has prayed for an adjournment on the ground of personal difficulty. The prayer is allowed. let this matter be listed. 16
No,
July.
May, my lord, May. May, death case, my lord.
May, sub.
Woman is bedridden, claim.
9th of June.
9th of June.
9th of June.
High levels.
Item 41.
May please your lordship. Some accommodation may be needed, madam.
My lord,
Meeting Eka is some
my lord,
parts
it's a
of it.
very, my lord, concerning matter because I'm appearing before on behalf of the respondent, who is a professor of my lord Dispur College. In 2012, my lord, he executed an agreement for sale of a flat, my lord. He paid more than 90% of the amount. The last is a very irrational demand for additional tax was made by the builder. He simply asked for clarification. The agreement was cancelled unilaterally by the builder. We went to the civil court, my lord. In the title suit, almost more than, my lord, 42 adjournments were taken by them. They left no stone unturned to ensure that the matter gets delayed. Even when the matter was posted for hearing, my lord, on many dates, my lord, they did not appear. Finally, we could do the hearing on our part, and they made a submission before the trial court that they will be filing their written argument, they will not make verbal argument. And on the date when the date was fixed for filing of written argument, they file a petition saying that they need some additional issues to be framed. The learned trial court deals with their application and rejects it. They come before the High Court in a CRP, my lord. High Court dismisses the CRP. Now that same ground has been, my lord, put before your lordship in the memo of appeal.
Dismisses the CRP thereafter.
Thereafter, my lord, the
Suit is decreed.
hearing proceeded, my lord, and the suit was allowed, my lord.
Suit is decreed.
Suit of the plaintiff was allowed.
Against the size.
My lord, see,
What was the relief granted?
relief
Refund,
granted was, my lord, specific performance of contract,
not refund.
and not refund, my lord.
Not
Specific performance of contract,
And also compensation.
and my lord, compensation. Compensation for unauthorized, my lord, depriving him of these amenities. my lord.
Whether the agreement, the sale deed has been executed, flat has been,
My lord.
whether flat is there,
Flat is there.
That is there.
is it
Flat is
vacant?
there because there was an injunction, my lord.
Is it vacant flat?
Second
Lordship,
plan, lordship. Second plan.
vacant flat, my lord.
Second plan.
But we are not in possession. Possession has not been given to us.
In spite of the,
In spite of all these orders, my lord, this, my client is going to retire now, my lord. All his life saving has gone to this flat, my lord. He has paid the bank loan. I have put everything on record, my lord.
My lord, what happened?
In
Why-
fact, my lord, as per
why this matter has not gone to the
RERA,
RERA?
at that, my lord, this 2012 agreement, so at that time, my
Oh,
lord, the RERA was not involved.
Okay. Yes,
My lord, what happened in the trial court, lordship? We are never in this process, lordship. Only we are engaging in this, only this matter, lordship.
My lord, in fact, my lord, if your lordship peruses the cross-examination, specific question was put to the, my lord, builder, that on what basis you are demanding extra tax? He said, I don't have any basis, my lord. They are so arrogant and so powerful, my lord.
I'm just asking for adjournment,
we
lordship.
will give a short date.
Yes, lordship.
My lord, at least,
We will reflect there in that no further adjournment.
lordship.
Lordship.
Suit
was of which year?
2014, my lord.
2014, lordship, and decrease.
When it was decreed?
2022, lordship.
2022, my lord. My lord, 42 adjournments were, as per my counting, my lord. It may be more than that, my lord.
I don't know, lordship, because I'm not
Heard.
in the trial court, lordship.
The record will leave, LCR is here.
Maybe.
This item number?
41, my lord.
Heard Mr. What is the name?
M. Das, lordship.
M. Das, learned counsel for the appellants. Also heard Mr. Rahul.
G. Rahul.
G. Rahul, learned counsel for the sole respondent.
My lord, I think there's another.
Who is appearing for others? Learned counsel for the respondent number one.
One, my lord.
Who is the performer respondent?
My lord, he was the landowner, my lord. In the suit also, we made him a pro forma defendant because he had given the land to the builder for, we don't have any dispute against him.
Okay. Learned counsel for the appellant submits that due to some personal difficulty, the conducting counsel for the appellants, namely Mr. B.D. Deka, could not appear now before this court today, and on that ground an adjournment is sought for. The prayer for adjournment is vehemently opposed by Mr. G. Rahul, the learned counsel for respondent number one. He submits that the suit filed by the present respondent number one before the trial court was in the year 2014 and it was decreed in the year 2022. He submits that even during the pendency of the title suit, the present appellant as defendants took several adjournments within bracket 42 numbers, and he submits that it is a deliberate attempt of the respondent number one to delay the execution of the decree which was granted in favor of the present respondent number one. Stop. I have considered the submissions made by learned counsel for both sides. Though the matter involved in this case is a very old pending matter. However, considering the submissions made by learned counsel for the appellant, one last adjournment is granted to the appellant's side. Let this matter be listed again.
Too late, my lord. May can pay for any time in first week of May, my lord. If not very
Before 30 April. Before 30 April. 29th April. 28th April. Let this matter be listed on 28th of April.
Delivery of order, item 1 and 2.
For reasons, corrections are said. For reasons mentioned in the orders, both the interlocutory applications are dismissed. You can go through the order tomorrow in the website. Oh, that will be returned. I have directed that original will be returned back to you.
My lord, the original except for the appeal book is with the case record.
No, yes, that will be returned to the government council. Wait for some time.
My lord.
Item 40.
May it please your lordship. Lordship, we have preferred this appeal against the interim judgment and order dated.
Who is for the other side?
The respondent counsel.
I'm
is there.
appealing, my lord.
We are challenging the judgment and order dated 10/3/2021 passed by the Railway Claims Tribunal in miscellaneous application number 33 of 2015. In the tribunal lordship, there was a delay of 5 months, 17 days in filing the claim application. The claimant have preferred the miscellaneous application being the miscellaneous application number 33 of 2015. And the learned tribunal lordship, as per section 4 of the Railway Claims Tribunal Act 1987, the member technical alone cannot adjudicate the matter, and lordship have passed a recent judgment on this aspect, lordship. In the present case also, lordship, the impugned judgment was passed by the member.
Unless it is authorized,
No?
unless there is a
Authorization. Yes.
authorization.
That authorization is also not there in the case, lordship. So, lordship, after passing of this impugned judgment, we prefer this appeal, lordship. And thereafter, lordship, the Honorable Justice
No, your claim was barred by limitation.
limitation.
Okay.
And our claim application was dismissed, lordship. Against that, lordship, we preferred this appeal. And this issue was dealt by the bench of the coordinate bench of this honorable court in MFA 54 of 2021, lordship. Here the delay was condoned. In some cases, delay was condoned, and lordship, subject to a condition that we have to deposit the cost of rupees 10,000. And in some cases, lordship, the appeals were dismissed. So, my lord, this is the judgment of the.
In some cases, appeals were dismissed, means
Appeals were dismissed because, lordship, their length of delay was higher than in the cases where the appeals were allowed, lordship. In some
My
cases.
lord, may kindly come to paras 37.
I'll come to you. Let her submit.
Yes, yes. Oh, I'll just load up on 37.
In the claim application, our main ground is, lordship,
What was the principle on which this judgment was? What was the ratio? What was the
ratio
reasoning of allowing some and disallowing others?
There are 37 days. 37, look.
lordship, from para 36, lordship, we kindly see.
Yes.
The ground of the claimant is there, lordship, in paragraph 36. So, common ground in the present case also. From the above conditions, it would be clear that the fault in not filing the claim application on time was due to the fault of the counsel. However, the appellants herein cannot be oblivious to statutory mandate of filing the claim application within time, and their responsibility do not come to an end merely by handing over the papers to their legal counsel. The litigant has to.
What is your stand in this case?
In the present case also, lordship, our stand is that the father of the counsel was ill, lordship, and because of that, the counsel could not proceed the claim application.
This plea you took before the Railway Claims Tribunal also.
Yes, lordship.
Okay.
And against that, lordship, we've challenged this judgment, lordship.
Okay. Read 36.
36. The litigant has to also see to that their counsel legal practitioner had duly filed the claim application within time, more so taking into consideration that the appellants before this court, who were the applicants before the tribunal, were regularly in the business of transporting goods through railways. Inaction on the part of the appellants tantamounts to sleeping over their rights, and aspect of gross negligence creeps into the fold. It may have been the appellants were under an impression that their counsel had filed their application within time, or the learned counsel for the appellant kept the appellants at dark that the applications were now not filed within time. There is no material brought on record to that effect except the submission made by the learned counsel for the appellants. The concept of reasonableness therefore has to be embedded in order to ascertain the question of due diligence, which in effect would also show as to whether the applicants were negligent in pursuing with their claim application.
Para 37. Upon applying the concept of due diligence, this court is of the opinion that a period of 3 months from the last date of filing the claim application can be taken as a reasonable period within which the appellants ought to have exercised the due diligence by making enquiries with their counsel and found out as to whether the applicants were duly filed or not. This is more so where there are no materials brought on record to show that the appellants were under impression that the claim application were filed on time after taking into consideration the proviso to section 17(1) of the Act of 1987. Any period beyond 3 months from the last date of filing, in the opinion of this court, cannot be constituted to be reasonable for condoning the delay, inasmuch as, in the opinion of this court, the same would negate the provision of section 17, subsection 2 of the Act of 1987.
What is 17?
Railway
Claims Tribunal.
Read.
Railway Claims Tribunal Act 1987. This section deals with limitation.
Read.
Page 9.
Page 9 of the Act, Lordship.
Please read.
Section 17, limitation.
17.2. Read 17.2.
Yes, sir.
17(1) proviso.
The claims tribunal shall not admit an application for any claim A under subclause 1 of clause A of subsection 1 of section 13 unless the application is made within 3 years from the date on which the goods in question were entrusted to the railway administration for carriage by railway. B. Under subclause 2 of clause A of subsection 1 or as the case may be, subsection 1A of section 13, unless the application is made within 1 year of occurrence. This regard to accident, railway accident, Lordship. This is not applicable in the present case.
Proviso.
Now C. Under clause B of subsection 1 of section 13, unless the application is made within 3 years from the date on which the fare or freight is paid to the railway administration, provided that no application for any claim referred to in subclause 1 of clause A of subsection 1 of section 13 shall be preferred to the claims tribunal until the expiration of 3 months next after the date on which the intimation of the claim has been preferred under section 78B of the Railways Act. 2. Notwithstanding anything contained in subsection 1, an application may be entertained after the period specified in subsection 1 if the applicant satisfies the claim tribunal that he had sufficient cause for not making the application within such period. So basically, Lordship, as per section 17, Lordship, 3 years time is there for filing the claim application from the date of booking, from the date on which the goods in question were entrusted, Lordship. So from the date of booking, the claimant have 3 years time to prefer the claim application before the Railway Claims Tribunal. And if the applicant satisfies the claim tribunal that he has sufficient cause for not making the application within the time, then, Lordship, the delay may be condoned as per this Act, Lordship, 17.
What is for proviso?
Proviso that provided that no application for any claim referred to in subclause 1 of clause A of subsection 1 of section 13 shall be preferred to the claims tribunal until the expiration of 3 months next after the date on which the intimation of the claim has been preferred under section 78B of the Railways Act. 78B is, Lordship, the mandatory notice that we have to serve to the railway administration. Now 78B is now section 106 of the Railways Act 1989. It is now substituted, Lordship. So this 78B under 106, Lordship, we have to give notice to the railway administration after expiration of 3 years, Lordship. We have to serve the notice.
And that notice has to be in written form. So that part is complied by us, Lordship. But the claim application has to be filed within 3 years. In that part, Lordship, there was a delay of 5 months, 70 days in preferring the claim application.
Now read para 37 of the judgment, which you have.
Now, Lordship, in para 37, the Honorable Court says that upon applying the concept of due diligence, this court is of the opinion that a period of 3 months from the last date of filing the claim application can be taken as a reasonable period,
Or
within which the appellants ought to have exercised the due diligence by making enquiries with his or her their counsel and found out as to whether the applications were duly filed or not. This is more so when there are no materials brought on record to show that the appellants were under impression that the claim application were filed on time after taking into consideration the proviso to section 17(1) of the Act of 1987. Any period beyond 3 months from the last date of filing, in the opinion of this court, cannot be constituted to be reasonable for condoning the delay, in as much as, in the opinion of this court, the same would negate the provisions of section 17 subsection 2 of the Act and tantamount to legislation by this court. So, Lordship, below 3 months, Lordship, delay was condoned in some appeals, and which was beyond 3 months, that delay was not condoned, Lordship. The total, Lordship, in this case, this is a common judgment.
how much delay is there in your case?
In my case, Lordship, there was a delay of 5 months, 17 days. So, Lordship, here, this judgment, as per this judgment, this case is covered by this case, Lordship, MFA 54. But now, Lordship, my question is, Lordship, whether the member technical has the power to adjudicate the claim while taking into consideration of section 4 of the Railway Claims Tribunal Act 1987. Because, Lordship, after passing of this judgment, Lordship, there is another judgment of this court where it was held that the member technical does not have power to adjudicate the claim alone, Lordship. I have that judgment of this court, Lordship, in MFA 38 of 2013.
No, but before that, you have to show that there was no authorization.
No delay.
Not delay. Lordship, here in the claim application, Lordship, my application for condonation of delay may kindly be perused, Lordship.
Yes.
Lordship, this application for condonation of delay is available in the LCR, Lordship.
Yes.
MA 33 of 2015.
Atul. Listen to this. Which page?
Lordship, Dada, file to please my side. Lordship, may kindly pass this file to me.
Yes.
First of all, Lordship, this application was filed by the counsel of the claimant, Lordship. Prayer for condonation of delay under section 17 subsection 2 of the Railway Claims Tribunal Act 1987. That this is a prayer for condonation of delay in filing the claim application. There is a delay of about 5 months, 13 days or less in the aforementioned claim application. The reasons for delay in filing this claim application are noted below. Number 1, that I regularly practice in the Honorable RCT Gauhati for about 25 years from now, and the present claim application was with me right from its inception. 2, that it is a fact that the above mentioned cases are mainly for refund of freight overcharge on account of wrong collection of terminal charges and serious calculation mistake by the respondent railways at booking point, and also wrongly collected panel freight at destination point. 3, that it is a fact that the number of cases were decreed by the Honorable RCT Gauhati in favor of the applicants, directing the respondent railway to refund of terminal charges to the applicant. Detail of such cases are noted below. 4, that it is a fact that in all the above cases, the respondent railway made an appeal before the Honorable Gauhati High Court, and after hearing the matter at length, the Honorable High Court, by their order dated 3/9/2013, in the item numbers 1 to 5, directed the respondent railways to approach the Honorable RCT once again regarding its grievances. And the item number 6 is still pending before the Honorable Gauhati High Court for adjudication, bearing Honorable High Court case number MFA 100 of 2011. 5, that it is fact that for a better understanding of the case in the light of the question relating to refund of terminal charges, I kept waiting for the judgment of the Honorable Gauhati High Court in the issue, but since there has not been any substantive conclusion till now, thus we decided to file the application before the Honorable RCT Gauhati without losing any further time. In addition to that, my client also had advised me not to wait any further and file the claim application before the Honorable RCT Gauhati for adjudication. 6, that the associate main reasons was also that I was unable to conclude my opinion regarding the filing of the cases in the RCT Gauhati, as the Honorable RCT Gauhati not functioning for last over 2 years, and also the same matter for refund of terminal charges pending for adjudication before the Honorable Gauhati High Court for proper adjudication on respondent railway appeals. 7, that apart from the above, the allied reasons also were that I was upset for last 12 months due to my old age father, aged about 77 years, who is suffering extreme high blood sugar and other old age complications for the last over 2 years, and due to that I was distracted from my work attention. 8, that the present case of my client had been under me from its beginning, and this freight refund claim originated due to railway overcharging freight money at booking point. My client will suffer irreparable loss if delays are not condoned. Details of delay for filing the cases in RCT Gauhati RR-wise are noted below. So there was a delay of 5 months, 13 days. So this is the prayer made by the counsel for the appellant, that these are the grounds, Lordship. And against that application, Lordship,
No, how counsel himself is filing application for condonation of delay.
yes,
It has to be filed by the applicant.
applicant. So, Lordship, this matter has to be adjudicated by the division bench, Lordship, because here basically the claimant can file the petition for condoning the delay, Lordship.
Yes.
And here the application was filed by the counsel for the claimant, Lordship. So this part has to be dealt in the judgment, but this part is not decided in the judgment, Lordship. This is the major mistake.
But on that ground also, the application would fail before the claims tribunal.
Correct.
Yes.
Let a chance may be granted to the claimant, Lordship.
No, what is your submission regarding division bench?
Lordship, as this matter is already decided in MFA 38 of 2013, Lordship. In this case, Lordship, as per section 4 of the Railway Claims Tribunal Act 1987, the chairman has the power to authorize any member, single member, to adjudicate the claim. But in the present case, Lordship, there was no such order
to support this thing, Lordship. Section 4, subsection 4 of the Railway Claims Tribunal Act, 1987. In paragraph 4, Lordship, it is stated that he further, the counsel for the appellant made a submission that Section 4, subsection 4 of the Railway Claims Tribunal Act 1987, though empowers the chairman or any other member authorized by the chairman of this behalf to function as a bench consisting of a single member and exercise the jurisdiction, powers and authorities of the claims tribunal. However, in that respect, an order, a general or special order has to be passed by the chairman specifying the classes of such cases or matters which may be taken up by a bench consisting of single member. However, he submits that in the instant case, no general or special order has been passed by the chairman of the Railway Claims Tribunal in terms of Section 4, subsection 4 of the Railway Claims Tribunal Act 1987. 5. He submits that the impugned judgment is therefore liable to be set aside and to be remanded back for fresh adjudication by a bench of 2 members in terms of Section 4, subsection 2 of the Railway Claims Tribunal Act 1987. 6. He submits that a similar issue was raised before a coordinate bench of this court in the case of Union of India versus Messrs. Bajaj Steel, MFA 113 of 2016, wherein the coordinate bench of this court had remanded the case in that appeal back to the tribunal for fresh adjudication. In support of his submission, the learned counsel for the appellant has also cited a ruling of the apex court in the case of Amulya Chandra Kalita versus Union of India reported in 1991 1 SSC 181. He submits that in the aforesaid case, though the apex court was dealing with the Administrative Tribunal Act 1985, however, Section 4 of the said Act contains similar provision like that of Section 4 of the Administrative Tribunals Act 1985, and the apex court held that in absence of a provision to the contrary, it is statutorily required that the tribunal must consist of 2 members, as the administrative member alone could not have heard and decided the matter. Ms. M. Sharma, the learned counsel for the respondent, also agrees to the submission made by the learned counsel for the appellant. I have gone through the materials available on record and have considered the submission made by the learned counsel for the parties. I have also gone through the rulings cited by the learned counsel for the parties. In the instant case, on a bare perusal of the impugned judgment, it appears that the same was passed by a bench consisting of a single member, that is member technical, and no order under Section 4, subsection 4 of the Railway Claims Tribunal Act 1987 is there on record to indicate that any authorization by the chairman to the member technical to take up the instant case by sitting singly was passed. 12. Since the statute clearly provides for the contingency in which a single member of Railway Claims Tribunal can take up the cases for adjudication, however, since said provision Section 4, subsection 4 of the Railway Claims Tribunal Act 1987 has not been complied with in the instant case, the impugned order is liable to set aside on the ground of lack of jurisdiction by a single member of the Railway Claims Tribunal. Same is accordingly done. The impugned order is accordingly set aside. The matter is again remanded back. So here, Lordship, as per proviso Section 4, subsection 4 of the Railway Claims Tribunal Act 1987, the Honorable Court held that the member technical alone cannot adjudicate the claims. It has to be decided by the division bench comprising of both member judicial and member technical. Accordingly, the matter was remanded back to the tribunal, Lordship, for a fresh decision. This is the recent judgment passed by this Honorable Court on 24/2/2026, Lordship. So in view of this order and the other judgments of this court, Honorable Court, Lordship, I humbly pray before this court, let this matter be remanded back to the tribunal, Lordship, for a fresh decision comprising of division bench, Lordship. Because here technical defects are there, Lordship, so this has to be dealt with the division bench only, Lordship.
Yes.
Here, so for the claim of concern, my lord, that claim without going to the claims raised, my lord, that on the ground of delay, these were rejected, my lord, which is put under challenge by the appeal, my lord. Now, the series of, my lord, cases where identical grounds were taken, my lord, were disposed of.
Before going to the grounds of limitation,
My lord.
you first address Section 4, Clause 4 objection.
Yes, my lord.
Whether it could have been taken up by single member who Who has passed the order, chairman or the
But technical.
Member technical.
whether member technical on his own?
My lord, so far
Do you have any thing to show that there was general or special authorization?
My lord, that will indicate from the record, my lord.
Go through the record.
Because what I want to submit, my lord, without there being any authorization, the member technical cannot see then take up the cases as per 4:4, my lord. Now, there must be some authorization. My lord, it's a speculation one, I understand, my lord. However, that the grounds taken, my lord, that is, when madam has just shown, my lord, para 23,
No, we will not go into grounds.
my lord.
If you're lacking jurisdiction, then after assuming jurisdiction, whether your decision is right or wrong, on that aspect, we have to go later on. First, we have to decide whether the member technical alone has the jurisdiction to decide. If you can overcome this, then we'll go into the merits.
My lord, to that particular pinpointed question, my lord, let me get the, my lord, instruction from the department also, my lord, whether at that particular time this this
Some
member
document-
technical was authorized.
Some document has to,
Authorization was there or not, I will place, my lord, if that is there. And there must be,
let him place.
Yes.
there must be, my lord.
Third, Miss, what is her name?
And Sharma.
N. Sharma, learned counsel for the
Appellant.
appellant. Also heard Mr.
BK Das, my lord.
B.K. Das, learned standing counsel appearing for respondent number 1.
Madam appears for respondent number 2. my lord.
Miss R. Devi appears for, who is respondent number 1?
My lord, Union of India through the general manager.
Okay.
Now the
Miss R. Devi, learned central government council appears for respondent number 2. Learned counsel for the appellant has raised a preliminary objection that the impugn order was passed in this case singly by Railway Claims Tribunal with only member within bracket technical sitting singly. She submits that though Section 4 within bracket 4 of the Railway Claims Tribunal Act 1987 empowers the chairman or any other member authorized by the chairman on that behalf to function as a bench consisting of a single member. However, in that respect, as per section 4, clause 4, an order, section 4, clause 4, a general or special order has to be passed by the chairman, specifying the classes of cases or matters which may be taken up by a bench consisting of a single member. She therefore submits that since the respondent side has failed to show any such general or special order, the impugn order passed by the member technical sitting singly is hit by section 4, clause 4 of the Railway Claims Tribunal Act, and the impugn order is, and same is liable to be dismissed on that count only. On the other hand, learned counsel for respondent number 1, Mr. B.K. Das, has prayed for some time to seek instruction as to whether at the time of passing the impugn order, whether there was any special or general order enabling the member technical to sit singly and take up the claims cases under section 4 within bracket 4 of the Railway Claims Tribunal Act. The prayer is allowed. How much time?
My lord, second week of May, my lord. Or as per the convenience, my lord, after, because these are, my lord,
Let this matter be listed.
Bihu vacation was also there, my lord.
How?
9th of June.
Yes, yes. Obliged.
Obliged.
If any such order is there, you have to
I'll place.
produce it.
There must be.
Item 42.
Itu recorded track. Recorded therapy. 42. Yes.
This appeal is under section 30 of the WC Act, Lordship. And the substantial question of law were framed by the court on 29/4/2022.
Workmen compensation.
And they are in my memo of appeal, page 5.
When the substantial question of law was formulated,
Lordship, on the day it was admitted, 29/4/2022.
yes.
Lordship. Should I read the judgment or I'll go to show the substantial question of law?
In judgment, we will find that.
Lordship. Judgment in my memo of appeal, it starts on page 7. Lordship.
Yes.
The claim case arose out of a claim petition filed by Muhammad Abdul Malik, aged 25 years, son of Samir Ali village, Panchmail, Tenga Basti, PO Pasmail, actually, PS Tejpur, district Sonitpur, Assam, praying for compensation under section 3 and 4 of the Employees Compensation Act 1923 from the opposite parties for injuries of himself in a motor vehicular accident arising out of and in course of employment on 16/1/2012. The case in brief is that Abdul Malik on 16/1/2012 was proceeding towards Tezpur from Lahari Ghat as a labor of the vehicle bearing registration number so-and-so truck. And on the way of his journey, when he reached near at Kudam Ghat, Tiniali, a truck which was parking on middle of the road without switched on parking light and without indicating any reflector of parking light and without took any precaution to save other vehicle which may easily cross from opposite direction. Suddenly a vehicle came. As a result, driver of the opposite party hit from the backside of the parking vehicle. As a result, driver of the opposite party died on the spot and the claimant Muhammad Abdul Malik sustained grievous injuries and he was admitted by the opposite party number 1 at Dispur Hospital, Gauhati, and doctor diagnosed and found type 3 compound fracture, both bone, L means left, I think leg, with degloving injury, R foot ankle with fracture, both bone, bore, L 4. Maybe there are certain mistakes, Lordship, I do not know. BOR, NR will be bone or something. and did operation and fitted steel rod and discharged, and he was under periodical checkup up to 3 months, but he was suffering pain even after operation and again admitted on 24 to 12 and on 25 to 12 debridement his fracture portion and discharged on 25 to 12, but his pain not fully cured, and at last consulted local Skylark Hospital, Tezpur, and Dr. DJ Deka examined him and again did operation and fitted rod and advised him not to do labor work or vehicle because injuries are in nature of grievous, and due to said injuries his leg became weak and not able to bend, and Dr. DJ Deka assessed his disability 40% and near about spent 3 lakhs, but documents submitted for rupees 1,53,660, I don't know, no, 1,53,667 10. The Collier police registered case and by PS case number 1612. The vehicle was duly insured with National Insurance Company, Tezpur branch, and at the time of accident, policy number so and so was valid from such and such date, and at the time of accident his age was 19 years. That the claimant filed the case and impleaded the owner of the vehicle registration number so and so and the National Insurance Company Tezpur branch jointly and severally for payment of compensation for injury of Abdul Malik. On receipt of the claim petition, a case was registered by case number WC case number 3212 and issued notice under section 21 of the Commissioner and Government of Assam, and duly notices were served to the concerned parties, OP number 1, Mrs. Anuvara Jahan, and 2, the National Insurance Company Limited of the vehicle registration number so and so. Both the parties filed their written statements. The claimant Abdul Malik adduced evidence SPW1 by an affidavit wherein he narrated the accident, employment under the employer salary, and in support of the claim petition, the claimant has also exhibited the following documents. Exhibit 1, FIR. Exhibit 2, notice under Section 10 of the EC Act 1923. Exhibit 3 to 3.2, medical discharge certificate. Exhibit 4 to 414, pathology report. Exhibit 5 to 539, prescriptions. Exhibit 6 to 673, cash memos. Exhibit 7, salary certificate. Exhibit 8, disability certificate. Exhibit 9, photograph of claimant. In view of the above pleading deposition from the parties, the following issues may be framed. Whether Abdul Malik was a workman within the Employees Compensation Act 1923 as amended, whether the accident arose out of and in course of the employment, whether the said claimant is entitled to get compensation, if so, what shall be the quantum and from whom? Decision and reason thereof. Issue number 1. From the above proceedings and exhibited document, it was admitted that Abdul Malik was employed as a laborer of the said vehicle by registration number so and so and sustained injury in the motor vehicular accident occurred on 16/1/2012 while he was laborer of the vehicle, which the opposite party number 1 admitted in the written statement. Accordingly, the issue number 1 is decided in the affirmative. Issue number 2, that the claimant has stated in his claim petition that he was a laborer of vehicle number so and so and sustained injuries in accident occurred during the course of his employment and exhibited documents in his favor. Therefore, it is held that accident occurred during the course of and out of employment. That issue number 1 clearly proves that Abdul Malik was an employee of opposite party number 1 and accident took place when Abdul Malik on 16/1/2012 were proceeding towards Tezpur from Laharighat as a laborer of the vehicle bearing registration number so and so truck. On the way of his journey, when he reached near at Kudam Ghat Tiniali, a truck which was parking on middle of the road without switch in parking light and without indicating any reflector of parking light and without taking any precaution to save other vehicle which may easily cross other vehicle, and from the opposite direction suddenly a vehicle came, and as a result driver of the opposite party hit at the backside of the parking vehicle. As a result, driver of the opposite party died on the spot and the claimant Muhammad Abdul Malik sustained grievous injuries and he was admitted to the opposite party number by the opposite party number 1 at Dispur Hospital, Gauhati, and doctor diagnosed and found type 3 compound fracture, both bone L, leg with deglobing injury R, foot, ankle with fracture, both bone, L, forearm, and from exhibit number 2, shin notice under section 10 of EC Act 1923 duly served. Accordingly, the issue number 2 is decided in the affirmative. Issue number 3. It is true that that Act is a benevolent and welfare legislation, and same should be liberally constructed, since the labor was a workman within the meaning of the Act, and the accident took place out of in course of employment in the vehicle number so and so truck. But the vehicle was duly insured with the National Insurance Company Tezpur branch, and at the time accident policy number so and so was valid from this and this, and took responsibility for compensation as per Employer Compensation Act 1923 as per agreement of policy. Being the insurer, it will have to bear all responsibility for payment of compensation to the claimants as per law, and from exhibited medical documents, it was seen the claimant sustained grievous injuries as type 3 compound fracture, both bone, L, leg with the Gauhati injury, R, foot, ankle with fracture, both bone, L, forearm. And from the exhibited documents 6 to 673, the claimant spent 1,53,667.10. He also exhibited 8 disability certificate which assess disability at the rate of 40%. But the claimant side not examine doctor for disability. Lordship will mark this part because one of my substantial question of law will be concerning this. Not examine doctor for disability, and his argument, the claimant side argued that the claimant had not called the doctor as a witness because doctor is not alive, and in argument states several judgments placed and argued that it is duty of the opposite party to bring doctor, and in support place judgment GLT 2010 volume 2 page 518 Oriental Insurance Company Limited versus AJ Thomas, and the claimant side also placed judgment in support of his claim GLD 2013 1 page so and so Muhammad Shafir Rahman versus United India Insurance Company Limited and others, that argued that due to injuries the claimant inserted steel rod. As a result, he could not able to bend his leg, and due to weak of his leg he is not able to do work as a laborer of vehicle. And advocate quoted para of judgment: if it is found from medical evidence that some destruction or permanent impairing of the powers of any member or joint have been caused from the injuries, that can be treated as permanent disablement. And also place judgment GLD 2013 1 page 8763 Shyam Babu Singh versus Sri Keshav Borua and others in support of the said case. And the claimant also argued that the claimant is suffering from permanent disability, and also stated as defined under section 2(1) of the Employees Compensation 1923. Total disablement means such disablement, whether temporary or permanent nature, as incapacitates a workman from all work which he was capable of performing during the time of accident resulting in his disability. Lordship, this I will again touch it, Lordship, later on with my substantial question of law. And in support of the claimant placed judgment in support of claim TAC 2005 1 page 57 Arjun Gangappa Kore versus Nirmal Bagshan brother and others, and also argued that as per section 4B Employees Compensation Act 1923, where the permanent total disablement result from injury, that then amount of compensation to 60% of the monthly wage of the injured, which is more. And in support the claimant placed judgment TAC so and so 2014 1 page 840 Bombay High Court Sanjay Bhimrao Sule versus Omkar Singh Harman Singh and another, TAC 2013 1 page 940 Orissa High Court Union of India versus Mamata Behra. In the present case, the evidence from records found that claimant was unable to perform the work as before accident, and at that time claimant was labor of said vehicle. The accident has caused an injury to him which has resulted type 3 compound fracture, both bone, L, leg with the glowing injury, R, foot, ankle with fracture, both bone, L forearm and still rod inserted, and as a labor's work required limbs to be functioning properly, and therefore a person whose rod inserted in leg obviously be unfit to do the work of labor, and doctor assess disability 40%. I am of the view that the claimant has suffered permanent disability. Lordship, I will address this also. The chairman himself is coming to a conclusion. I am of the view that the claimant has suffered permanent disability as he is not doing same work as he was doing prior to accident. Hence, the claimant is entitled to get compensation as per Section 4B Employees Compensation Act 1923. Accordingly, the issue number 3 is decided in the affirmative. Lordship, I will be also touching Section 4B of Employees Compensation Act. As regards to age of the injured at the time of accident, it transpires in record found 19 years completed, which is accepted, and the claimant stated in his statement rupees 7,000 monthly salary, and owner stated in written statement salary rupees 7,000 per month, exhibited salary certificate number 7, also proof 7,000 per month, hence rupees 7,000 is accepted. The amount of compensation is computed as follows: 60% monthly wage of 7,000, 4,200. Relevant factor for the year of age 19 to 25.22. So the calculation, the and the medical expenditure after adding that, the compensation arrived at is 10,99,591. The claimant is entitled to get compensation of 10,99,591 as the said vehicle was duly insured with National Insurance Company Limited, Tresco branch at the time of accident, policy number so and so, and valid from so and so. Hence, opposite party number 2 is liable to pay compensation. That the interest on award amount will be 12% from the date of accident. Referred the following decision. TAC 12 volume 4 page 4 Supreme Court Oriental Insurance Company versus CB George and others upheld the decision of 4-judge bench of the Honorable Supreme Court in Pratap Narayan Singh Deo versus Srinivas Sabata AIR 1966 1 SCC 289 and 1976 TAC 348 SC that an employer becomes liable to pay compensation as soon as the personal injury is caused to workmen by the accident. Thus, the relevant date of determination of compensation, rights and liabilities of the interest to be borne by parties is the date of accident, not from the date of adjudication. In view of above discussion and decision thereon, the opposite party number 2, National Insurance Company Limited, Tezpur branch, and policy number so and so, which was valid from 19/6/11 and 18/6/12, is hereby directed to deposit the total amount of rupees 10,99,591 only within 60 days, and in default 12% interest will be borne per annum from the date of accident till realization. However, if the opposite party number 2 prefer an appeal against this order, it shall have to deposit the awarded amount with the undersigned and obtain a certificate thereof in accordance with Section 30 of the Employees Compensation Act. This also I will address, Lordship, because this direction is not correct as per our own High Court judgment. Given under my hand and seal on this 27th day of February 2019, furnish the copy to the concerned. So this is the judgment, Lordship. Then I mentioned my grounds, Lordship. Ground A, Lordship. Learned Commissioner ignored own objection made at page paragraph 5.
What is the substantial question?
Yes, substantial question of law, Lordship, page 5.
These are the same substantial question
Yes, Lordship.
which were formulated by the court.
Court, yes, Lordship.
Yes.
Lordship. Now, Lordship, we will take Employees Compensation Act, Lordship. Section 2G. The court has quoted some part of this 2G lordship, but not fully. At page 11 of the judgment lordship. But I'll read the
Yes.
partial disablement means where the disablement is of a temporary nature, which such disablement as reduces the earning capacity of an employee in an employment in which he was engaged at the time of the accident, resulting in the disablement, and where the disablement is of a permanent nature, such disablement as reduces his earning capacity in every employment lordship. This every word is missing from the judgment lordship. Which he was capable of undertaking at that time, provided that every injury specified in Part 2 of Schedule 1 shall be deemed to result in permanent partial disablement, Lordship. So, Lordship, there is, in this present case, Lordship, there is no evidence of the doctor proving, because requirement of WC Act is that a medical practitioner will prove the disablement.
Where is that?
Lordship, next one. HI, Lordship. Qualified medical practitioner means any person registered under any central act, provisional act, or an act of the legislature of a state providing for the maintenance of a register of medical practitioner or in any area.
It only defines medical
Yes,
practice.
Lordship. I'll now show Lordship our High Court judgment, Sanjeev Kumar. Yes. Nama saya sudah itu aja nak kata. 2001 ACJ 1690.
2001 ACJ.
ACJ 1690.
1690.
New India Assurance versus Sanjeev Kumar. Lordship, here, Lordship, we can go to the relevant paragraph is the workman compensation.
Para?
Para 4, Lordship, when the year was remanded. Or Lordship, we can read from para 2.
Yes.
I heard Mr. S.K. Borkotuki, Learned Counsel for Appellant, and Mr. G.P. Bhomik, Learned Counsel for Respondent. It is argued by Mr. Borkotuki, Learned Counsel for Appellant as follows, that the mode of assessment of loss of earning capacity and the person competent to assess it has been provided in Section 4 of the Act. While judging the loss of earning capacity, the basis of sound principle of medical science as assessment done by a qualified medical practitioner plays a vital role. Who is a qualified medical practitioner has also been defined under the Act. The degree of disablement and loss of earning capacity are not synonymous. There must be a basis for it, but not mere guesswork. And as such, while doing assessment of the loss of earning capacity, the qualified medical practitioner will have due regard to different injuries specified in Schedule 1. If the commissioner does not keep in view the requirement of law and passes an award, such an award involves substantial question for determination in an appeal, and as such, an appeal lies in this court as contemplated under Section 30 of the WC Act. In view of the specific requirement of the provisions of Section 41C2 of the Workmen Compensation Act that the loss of earning capacity is to be assessed by a qualified medical practitioner, it cannot be said to be mere formality. The qualified medical practitioner also cannot assess the loss of earning capacity in his guesswork, that the nature of injuries, the percentage of physical disability, the capacity of the injured to perform the nature of work with specific preference to the type of work he is engaged in, and several other factors to come to a finding with regard to the loss of earning capacity. In that view of the matter, in absence of evidence of the doctor in that regard, it is not permissible. So, Lordship, this part, Lordship, absence of evidence of in that regard, it is not permissible for the court to find out only from the evidence of physical disability to the extent of loss of earning capacity. The Commissioner Workmen Compensation in the present case at hand, having assessed the loss without any specific evidence of the doctor as required under the law, the award judgment is not sustainable in law. On the other hand, Mr. G.P. Bhaumik, Learned Counsel for Respondent, submits that even if the percentage of disability have not been assessed by the doctor, the court, in order to do speedy justice to the poor workman, can assess the loss of earning capacity and award compensation. The Workmen Compensation Act provides the mode and method to determine the compensation. The court cannot adopt some mode or method which is not provided in the Act. In the portion of the award quoted above, the court determined the percentage of loss of earning capacity at 50%. That power is not available to the Commissioner. Lordship, this is important for our case also. So this award shall stand quashed, and the matter now shall go back to the Commissioner to assess the compensation afresh. And in order to do that, he may even ask the doctor to appear before him and give his opinion with regard to percentage of loss of earning capacity. So
Loss of earning capacity has to be assessed by court.
no, doctor.
How doctor will assess?
Uh,
Doctor will assess the injury, disablement also.
No, in MSCT is different, Lordship. In MSCT, the tribunal has the power.
No, you show me the substantive provisions, section 4.4,
Yes, Lordship.
where it is mentioned that earning capacity is to be assessed by doctor. Come to 4.2, 4C2, which
Yes.
has been relied upon.
Yes, Lordship. Lordship went to the correct. That is the provision.
Yes, read it.
Yes. In the case of an injury not
And
specified.
subject to the provisions of this act, the amount of compensation shall be follows, namely where the permanent partial disablement result from injury. In the case of injury not specified in schedules, such
Lordship, Schedule 1 is that where there is amputation, where it is loss of ear, and
such percentage of compensation payable
in the
in the
case
case of permanent total disablement
as is
is proportionate to loss of
as
earning.
assessed by the qualified medical practitioner, permanently caused by the injury. In MAC cases, Lordship, it is different. The tribunal can assess, but that's why there is substantial question of law in WC cases, Lordship, and not substantial question of law in. So our present case will be a case of remand only. Other grounds also, Lordship, on that remand only.
Just now, what is your submission?
So, Lordship, it will be other judgments are also there, Lordship. Rupchan Ali also from our High Court, Lordship, MFA 186 2017, Lordship. In that also, as per Bimalnath's case, Lordship, should I give all the judgments? Lordship always asks me to give
No.
judgments.
Now, in this case, the only observation is that power is not available to commissioner.
Yes, Lordship, I'll give a
There.
Supreme Court judgment, Gola Ranjana, where it was observed that in the High Court doesn't have the power to assess. It has to remand back. Gola Ranjana. It to DD. Paragraph 11, Lordship.
Such percentage of compensation payable in the case of permanent total disability. No, you make me again understand.
Yes, Lordship.
In section 4(1)(c), clause Roman 2, what is to be assessed by a qualified medical practitioner? It is the permanent total disablement is to be assessed or loss of earning capacity.
Permanent disablement also and loss of earning capacity also. That other judgments are also there in our here also. The language will be, I'll read just the.
Or assessing permanent total disablement, medical qualification is necessary.
No, he has to be just any. That's why I read one.
For that, you must have specialized knowledge in medicine.
No,
But
that's why I've read 1G, Lordship. The definition of medical practitioner. He has to qualified medical practitioner, not 2I, Lordship.
No, what I'm on is there any judgment which is clarifying that what this within bracket in Roman 2, 4(1)(c) Roman 2, it is mentioned within bracket as assessed by qualified medical practitioner. What
But
is
that is in the act itself, 2I, Lordship. That's why I read that 2I. It is there. Qualified medical practitioner, Lordship. He doesn't have to be.
that is not my query.
Okay.
My query is try to understand my query. Then you make me understand.
Yes, sir.
My query is merely because after the words earning capacity, bracket starts, and therein, as assessed by qualified medical practitioner is mentioned, you are saying that the loss of earning capacity is also to be assessed by doctor. But before the words loss of earning capacity, loss of earning capacity has to be proportionate to the permanent total disability.
The case of permanent total disablement as is proportionate to the loss of earning capacity
Yes.
as assessed by. Yes, Lordship, that has.
Now, whether the permanent total disability has to be assessed by a doctor or the loss of earning capacity has to be.
No, both, Lordship. Otherwise, how the commissioner will know what is the disablement? In all cases, Lordship will find in WC cases, Lordship, medical practitioner assesses.
Assesses what? Loss of earning capacity. But for assessing, without going into act, for assessing loss of earning capacity, do you need medical knowledge?
Yes, Lordship.
For assessing the permanent disablement, you need medical knowledge. How much disablement due to fracture of bone? What is the percentage? But what you are earning earlier, how much you will?
How much earning is not, they decide if that disablement will have loss of, what percentage of loss of earning will be there. Not on what amount, like if he was 3,000 earning 3,000 or not like that, but in general, that he this
No,
disablement.
to my understanding, that is an aspect to be decided by a judicial authority on the basis of materials.
But Lordship, naturally he'll agree, Lordship.
He's disturbing you.
Agree with you.
No, Lordship, our
No.
other one judgment paragraph, I just want to read to make this clear.
Yes,
Lordship.
yes.
This is another judgment of our High Court only.
Which judgment?
MF in bracket A 43 of 2011, Oriental Insurance versus Mohammed Furat Ali, alias Farid Ali and another. Lordship, paragraph 11, I'll read of this judgment. In the judgment reported in 2009, here also the same thing came up. Lordship, many judgments are discussed in this case.
No, but you give me a judgment which clearly discusses, because the judgment,
Lordship, if this makes
because the judgment which you have referred now,
Hmm.
that is
Sanjeev Kumar,
Sanjeev,
Sanjit,
Kumar, it only mentions one line, the power is not available with the commission.
and Gola Ranjana also, Lordship. That's
It
why
does not clarifies why this power is not available.
Gola Ranjana, and I'll read Gola Ranjana. I'll read two paragraphs of two different judgments. Gola
Yes.
Ranjana, I'll read, Lordship.
Yes.
Where this is Supreme. Under the scheme of the Act, the Workmen Compensation Commissioner is the last authority on facts. The Parliament has thought it fit to restrict the scope of the appeal only to substantial question of law, being a welfare. Unfortunately, the High Court has missed this crucial question of limited jurisdiction and has ventured to reappreciate the evidence and recorded its own finding on percentage of disability, for which also there is no basis. The whole exercise made by High Court is not within the competence of the High Court under Section 30 of the Act. Now, Lordship, our High Court judgment I am reading. In the judgment reported in 2009, 1 GLT 138, this court held that commissioner awarding compensation on the basis of the certificate of claimant's physical disability cannot be a substitute for loss of earning capacity. The said decision, while discussing section 4(1)(c)(2), held that the qualified medical practitioner has to determine the percentage of loss of earning capacity.
Which decision it is referring?
It is Lordship 2009 1 GLT.
No.
2009 1 GLT is New India Assurance Company Limited versus Abdul Kalam.
Where is that decision?
Lordship, I did not bring that judgment because in this judgment it is mentioned. Abdul Kalam, I'm giving this Lordship for the 10, paragraph 10 also I can read, Lordship. That is para 10. I have perused the record and found that the doctor who issued the medical certificate was not examined and the disability shown to be 35% as apparent from the medical certificate, which has been considered by the learned commissioner to be loss of earning capacity of the respondent number 1, Mr. Goswami, in support of his argument, also relied this judgment. Paragraph 11. In the judgment reported in 2009, 1 GLT 138, this court held that commissioner awarding compensation on the basis of the certificate of claimant's physical disability cannot be a substitute for loss of earning capacity. The said decision, while discussing section 4(1)(c)(2), held that the qualified medical practitioner has to determine the percentage of loss of earning capacity in case of different injuries not specified in Schedule 1. Similarly, the decision reported in 2009 ACJ 807, this court supported the view that the evidence of medical witness is a condition precedent for assessment of the disability of the injured person so as to enable him to claim the compensation under the Act.
This last line is okay.
Yes.
Assessment of disability of the physical disability can be assessed by doctor, but earning capacity has to be assessed by doctor.
Lordship, then I'll read the other paragraphs also, Lordship. 12.
Yes.
This is a case wherein injuries referred are not specified in Schedule 1 of the Act. Under such circumstances, a duty was cast upon the learned commissioner to assess the loss of earning on the basis of evidence of a qualified medical practitioner. This is clear. Instead, the learned commissioner on his own, without taking the assistance of qualified medical practitioner, assessed the loss of income for the assessment of the award and accordingly failed to apply the jurisdiction as stipulated under the provision of the law as herein above stated. Accordingly, the substantial question of law is decided in favor of the appellant. On the submission of the learned counsel on behalf of the appellant, the substantial question number 2 has not been discussed, which has become redundant after judgment of Amiruddin case versus New India Assurance Company. This was on some other. Keeping in view the discussion herein above made, I hereby set aside and award set aside the impugned award impugned herein this appeal passed in case number so and so workman compensation dinner and remand the same to pass a judgment afresh, keeping in view the observation made in this judgment. The learned commissioner or receipt of the case record shall notify to each of the party for appearance, send down the case record. So, Lordship, here it is made clear.
Okay.
And
What is your submission as regards first substantial question of law?
first, so then resultant would not pursuing every employment the commission. That Lordship, one is Lordship regarding that section 2G, what I said, Lordship. Every employee, they have not given neither the doctor nor the claimant. Doctor did not deduce any evidence. Claimant has not said he will not be able to do every kind of employment. Lordship, for that I will like to rely on the judgment of Bimalnath, or this is a
No, but is it a substantial question of law?
Apuni to ko Lordship, it is a substantial question of law because what is specified in section 2G, maybe the substantial question of law can be formulated in a different manner, that whether it falls under 2G, the compensation given under falls under 2G, and also 4B, Lordship. It is not a question of fact because assessment, Lordship, 4B is when the workman was not able to pursue every employment, Lordship, the commissioner could not have assessed it as per 4B of EC Act, Lordship. Actually, 1 and 3 are more or less same, Lordship. Substantial question of law, 1 and 3.
And second one, okay.
Second one, I already answered, Lordship.
Yes.
Because they said that the doctor had died. If the doctor had that, they should have taken the assessment from some other, or the commissioner should have called for it. That is what our High Court judgment says, Lordship. And Lordship, on this substantial question of law 1 and 3, Lordship, I would like to rely on this judgment of our High Court. Brother?
Yes, Putul. Era?
Lordship, if I should not read all the Lordship, paragraph number are not given, Lordship. Page 3, Lordship, from top 1 to 3rd paragraph, after careful scrutiny.
Yes.
After careful scrutiny of the materials available on record, this court finds that there is no evidence led by the claimant to show that he was not in a position to accept other forms of employment which he was capable of undertaking on the date of accident. On the contrary, the testament of PW2 clearly goes to show that the claimant was in a position to undertake other employments. Since there is no dispute about the fact that the injury suffered by the claimant is not scheduled injury, hence having regard to the law laid down by this court in the case of Bimal Nath, the learned commissioner, in the opinion of this court, has erred in law in assessing the compensation under section 41C2 of the Act of 1923. In view of the above, the impugned award is held to be unsustainable in law and the same is accordingly set aside. As regards request of Mrs. Saikia to assess the compensation instead of remanding the matter back to learned commissioner, it is to be noted herein that the Honorable Supreme Court has categorically held in the case of Gola Ranjana that I have already submitted, Lordship, that under the scheme of the Act of 1923, the Commissioner of Workmen Compensation is the last authority on facts, since assessment of compensation would warrant as warrant ascertainment of various facts on the basis of appreciation of evidence. I am of the view that the law laid down by the Supreme Court in Gola Ranjana, etc., Supra, would not permit this court to reappreciate the evidence and record factual findings for the first time at the appellate stage. As such, the request of Mrs. Saikia cannot be accepted. However, considering the fact that the accident in this case has occurred in the year 2009, the learned commissioner is requested to determine the amount of compensation in this case as expeditiously as possible, preferably within 3 months from the date of receipt of LCR. The appeal stands allowed to that extent. So for 1 and 3, Lordship, I'm giving this judgment, Lordship. Vimalnath also I could have given, court has referred.
Where is that phrase, every employment?
Every employment, Lordship, 2G. Partial disablement. That is in inverted comma because the definition is given, Lordship. Section 2 of the Act is giving all the definitions of different words.
Yes.
That is my submission, Lordship. Anything comes up, I'll give a reply.
May I please, Your Lordship. My Lord, my learned friend has submitted about the permanent disability or temporary disability earning capacity. My first answer will be, my Lord, the facts, Your Lordship, she has already narrated. My Lord, here the functional disability has not been ascertained by my learned friend. She is on the permanent disability. Whatever the functional disability, because
Her submission is that
I'm coming.
even that is to be ascertained by a
commissioner,
medical practitioner.
practitioner, my Lord. It will have to go. This is, my Lord, by Jammu and Kashmir, on pronounced the judgment on 25/3/2026. I'd like to take your lordship to the
Citation to go.
citation to divisional manager, JK for State Forest Corporation, Division Bhattacharya Satish Kumar. Well, I'd like to take your lordship to the paragraph the issue was also that, my lord, whether the extent of the disability suffered by the appellant, OPP, my lord, that is your lordship, they had discussed all the judgment. Your lordship will find from para 8 onwards, my lord. From para 8, then I will come to my lord, para 11, then 12, 13, and 14. Here the Supreme Court also discussed, my lord. It is only the commissioner has the power to decide his functional disability. It is not the doctor. It is only the commissioner, my lord. Question of facts.
Yes, read which, where,
Give me the paragraphs. my lord. The Lord, she will come to the paragraph 11.
finding.
Finding. my lord. Heard the learned counsel for the parties, peruse the file and consider the matter. From 11. Essentially, the two questions have raised in the appeal, as argued by the learned counsel for the appellant employer, that functional disability suffered by the claimant has not been certified by the doctor. As such, the commissioner was not competent to decide the matter with regard to the permanent disability of the claimant as to the assess the compensation available to him. That the treating doctor had not been examined by the claimant and the medical report, who was simply a MBBS doctor, had made a statement on examination of the claimant, and on the basis of the record of his statement cannot be stated that expert as to be an expert witness so as to ascertain the physical and functional disability by claimant and to assess the loss of income as awarded and fair compensation. 13, 12 paragraph. The apex court in the case titled Fulmati Dharmandev Yadav and the New India Assurance Company reported in 2023 and INSS while discussing the appellate jurisdiction in term of 30 of the employees' compensation held that an appeal under the commissioner can be entertained only if there is a substantial question of law to be considered. By that, the substantial question of law is to be understood by the general meaning. Naturally, the reference of the Civil Procedure Code that framing of substantial question of law is a cardinal importance of existence of such a question is the prerequisite to the appeal being entertained. It was further held that the commissioner, being the last authority of facts, on facts, the scope of appeal under the Act being limited only to substantial question law, if some perversity could be demonstrated from the order of the commissioner. Next paragraph. The apex court had clearly held in the case reported 2017 SCG that the finding on the nature of injury and the percentage of injury suffered by the workman is purely the question of facts. And under the scheme of workman compensation, commissioner is the last authority of the facts. It is not necessary for the doctor to say what is his percentage of functional disability or permanence. Only he will say.
In which case it was held?
My lord, in the workman compensation case, my lord.
No, it has referred to a case.
Reported in 2017 ACG.
Have you verified that?
My lord, actually, in the morning, I have just find out this one. 2017 ACJ 1, my lord. Lord, she will find it from here. It is Gularanjan, my lord, 2017. Gularanjana, my lord.
This is Golaranjan's case.
The case, my lord.
Now, show me in Golaranjan where.
Yes, my lord. Golaranjan.
Where it has been held that.
Yes.
The functional disability is to be assessed by.
Your lordship will come to the page 10, paragraph 10, Golaranjan. Impossible. 10. Workman compensation commissioner, having regard to the evidence, had returned to the finding that the nature of the injury and the percentage of disability. It is purely a question of fact. There is no case for the insurance company that finding is based on no evidence at all, or that it is perverse. Under section 4(1)(c)(2) of the Act, the percentage of permanent disability need to be assessed by the qualified medical practitioner. There is no case for the respondent, but that the doctor who issued the disability certificate is not qualified medical practitioner as defined under the Act. Thus, the Workman Compensation Act has passed the order based on the certificate by disability issued by the doctor and which has been duly proved before the Workman Compensation Act. Under the scheme of the Act, the Workman Compensation Act is the last authority of facts. The Parliament has a thought to fit to restrict the scope of the appeal only in the substantial question of law, being the welfare registration. Unfortunately, the High Court has missed this crucial question of limited jurisdiction and has ventured to reappreciate the evidence and record its own finding on the percentage of disability, for which also there is no basis. The whole exercise made by the High Court is not within the competence of the High Court under the section 13 of the Act. This is Gulab Chandra. And then your lordship will come.
No, you show me any authority suggesting that the commissioner, without an assessment made by medical practitioner, can himself assess the functional disability.
My lord, particularly in that way, my lord, it is not there. It's so far my
That
finding.
is the core submission of the appellant side, that without any assessment of functional disability, loss of earning capacity by the doctor, commissioner itself came to a finding.
Yes, my lord, it is clearly stated here in my lord. So far functional disability is concerned, my lord, it is up to the commissioner.
Where?
This judgment, Jammu and Kashmir, which I have given, it is clearly stated in paragraph 13 and all. It is only the commissioner, his question of facts. He will only understand the functional disability. To Supreme Court. I am submitting here another one, my lord, Supreme Court. It will honor Indira Bai, Bhattacharya Oriental Insurance Company. Your lordship will go to paragraph 28. Paragraph 28, my lord. Your lordship got it, my lord.
Yes.
In the light of the aforesaid decision and the definition of the term total disability as provided in the clause 1 subsection 1 section 2 of the Act, it is the functional disability and not just the physical disability which is determined factor in assessing whether the claimant has incurred a total loss. Thus, if the disablement incurred in the accident, incapacity as a workman for all work which he has capable of performing at the time of accident, resulting in such disability, the disablement would be taken as a total and for the purpose of award under the section 4(1)(b) of the Act, regardless of the injury sustained being one as specified in the part 1 of the schedule 1 of the Act. The provisions of clause 1 of subsection 1 of clause 2 does not dilute the import substantial cause. Rather, it added by specifying the categories wherein it is deemed there is a permanent total disablement. So, my lord, the other judgment also there, my lord. The first title clearly shows that, my lord, that it is the commissioner who will decide the fact about his.
You are citing something else and submitting something else. This decision fortifies the appellant submissions.
Yes, my lord.
That disability should that the disability should disable the workman from doing all works.
It is the functional disability and not just the physical disability, my lord. The capacity of the person, whether he will, after this injury, whether he, what is his functional, what is capacity of functioning, who is to determine? The doctor cannot determine that. It is the commissioner, my lord.
Where is that?
That I have said, Ghulam Smith, question of facts, only the sole authority is the commissioner. This judgment, my lord, which my learned friend also relied upon. Then that paragraph 10 and 11, my lord, the question of facts of determining disability. Then, my lord, I have given one Karnataka High Court case, my lord, 2018. This is Northeast Karnataka Road Transport Corporation versus Sujatha. My lord, these judgments are all discussed in the Jammu and Kashmir High Court judgment, my lord. In the Jammu and Kashmir judgment, if your lordship comes to the paragraph 15, your lordship's queries has been attended by that also.
Yeah.
Paragraph 15, my lord. The contention of the learned counsel for the appellant employer that permanent disability has to be assessed not by the commissioner, but by the medical expert. Though the learned commission has not clearly stated in the award with regard to the assessment by the medical expert as regard the disability, however, regarding the statement of the medical report and then it is found that he has certified to given to work of the claimant suffered 100% disability. Even this medical report was cross-examined by the appellant, who stated that he had made his statement on the basis of the certificate issued by the doctor so-and-so. It appears that the appellant, being the examination of the medical report, has not raised any objection with regard to the competence of the to depose the material
No,
expert.
in this case,
Yes, my lord.
doctor was examined.
Yes, my lord.
But in the present case, there was.
Yes, doctor has died. The insurance company has never filed any petition to call for the expert. And I relied upon our High Court decision of the 2G judgment. That they are the one who is to call for the expert. That is, my lord, 2012. No, first 2012. Let us speak about 2010 also.
12, citation to
Yes, 2010, upon our whole. 2000 GLT, 2010, 2 GLT, BK Moshahari judgment, Oriental Insurance versus A.S. Thomas.
No, this is a case under motor accident.
My lord, but the law is that, my lord, the doctors, if they want to examine the doctors, their certificate, they have to file a petition, my lord. Even in Jammu and Kashmir also, my lord, they have stated that. They are the one who has to file for evidence, my lord. Otherwise, it is admitted.
In the instant case, there was a certificate by doctor, but he was not examined.
Yes.
That is your objection.
My case is, my lord,
in
the certificate.
Ali also
but
that is what happened.
My lord,
That's why Justice Suman Sham has sent back.
that is what I am saying, my lord. That doctor has died. On the basis of the facts, my lord, the commissioner is the sole authority to examine that past. And if they want to challenge the medical certificate, they should have filed the application. That we want to
Where is
examine.
that observation in this A.J. Thomas case?
My lord.
Latest case which you have relied.
A.J. Thomas case, my lord.
Which para you are relying?
Yes, my lord, I'm just coming, my lord. Yes, paragraph 11.
Yes. Yes. If any other submission, we'll go through it later on.
My lord,
Go through this judgment later on. Any other submission?
my lord, this is my submission, my lord, that doctor need not be called for the functional disablement, for assessing the functional disablement. It is only the commissioner. And if they want to examine that certificate, they challenge the certificate of disability, there is scope for them to call the doctor or any other expert.
It does not appear very convincing.
My lord,
Your submission,
yes, my lord.
unless you show it from the judgment.
That doctors must assess that disability,
No, that the other side should call the doctor.
because I've given it that, my lord. 2000. What I could have given the Justice 2009 Supreme Gauhati, my lord, para 11.
Para 11.
Yes, in this appeal, the appellant has seriously questioned the findings of the tribunal on the permanent disability without taking any evidence of the doctor and awarding compensation. In this regard, it is noted that the respondent claimant produced the necessary medical certificate before the learned tribunal, and the appellant had the opportunity to produce the same. No doubt the respondent claimant did not examine the concerned doctor, but appellant at no point of time made any prayer before the learned tribunal to summon the doctor concerned for examining to testify the veracity of the medical report, and thus it failed to avail the chance of calling the material witness. Para 11 of the yes, but already in the judgment it is given there in the MSc, I mean the judgment by the workman compensation in para 5, my lord. 11, my lord. Page 11. The duty of the opposite party to bring on record the support placed undergoing the GLT, this given there in the judgment is clearly discussed, my lord. Where is the perversity, my lord, in this judgment? It is there, did not avail the opportunity. Because if their contention is that the capacity, earning capacity has to be decided by the doctor, then it is their duty, my lord. They have raised the question. In the written statement also they have get the opportunity. They didn't raise that question, my lord.
The Jacob case to MSc case असेल नाही की WC असेल.
No, WBC.
Okay. You reply later on. Let me go through this judgment, Golaranja's judgment.
Okay.
That appears to be relevant.
Relevant.
So let me read the judgment.
Yes.
I am fixing a date for your reply.
Okay.
On that day,
Jacob
and if you have anything to make submission, you
my
can
lord.
also make.
Your lordship's query is that the doctor has to assess
I'm
the
not replying
functions.
to what is disability. He is again and again relying on disability. It is not a question of our question.
It's a functional disability. not a-
Functional disability, fine. No issue with that.
Functional disability.
Loss of
He
earning
may have a permanent disability, but what
We-
about his function?
We are on loss of earning, lordship.
Let me put the query.
Yes, my lord.
As per section 4(1)(c)(2), 4(1)(c)(2), the permanent disability proportionate to the loss of earning capacity is to be assessed by a medical practitioner.
Is to be assessed.
That is the
Whole question.
language of the statute.
Yes.
And the contention of appellant is that in this case, doctor was not assessed, doctor was not examined, and the permanent disability was assessed by the commissioner without relying on doctor's evidence.
My
That
lord,
is a-
that aspect, my lord, is just.
So there is a fault.
There's a conflict, but here is what I submit, my lord. That doctor has died. My contention is this, that doctor has died, it is reflecting judgment. Then what will be the proposition, my lord? If the doctor has died, it is the duty of the insurance company to call for an expert or to some other person, whether they have submitted that application, my lord.
Where is the law, Lordship?
That I have given, PK Mushahari, my lord, of our
the
High Court.
WC Act.
My lord.
Where, WC
My
Act,
lord,
where is the law?
is
that
there any
insurance
difference between the WC Act is also from the Motor Vehicle Act, my lord, that has been taken, my lord. Because your Lord Talapatras, Justice Talapatra in my lord 2012, Gauhati, my lord, it is also stated, my lord, workman compensation, the doctor need to be called by the respondent, not by the appellant, if he is not there. If they challenge, whether they have challenged that medical report in the trial court, my lord. They have not challenged that. Now that cannot be the substantive question of law in the appeal, my
Okay,
lord.
what is your reply?
I'll
They have
reply
not
on the
challenged
next
that.
date, Lordship. It is no use because I'll be saying something, he'll be saying something. So,
Miss R.D. Majumdar.
okay, Lordship, since there is time, I'll just, yeah, where is the law, Lordship, that we, what is the requirement? If they are asking for compensation, that is what I showed, Lordship, 441C2. They have to prove it, Lordship, not the insurance company has to prove it, Lordship. It is not like that. And MAC case and WC cases are with different, Lordship. In MAC cases, appeal, we do not have to give substantial question of law. But here, there has to be substantial question of law. So, and I have already given all our High Court judgment.
And if the court comes to a finding that this question is not a substantial question.
Then it's gone.
No, Lordship, already I have given the judgment that commissioner cannot decide. That is substantial question of when 41C is there, Lordship.
No, suppose Commissioner 41C is very clear. If we go by that,
Yes, it's very clear.
then how it becomes a substantial question. Substantial question of law is a question which is in the gray area, which has not been decided by any court.
Okay, I'll give reply to
On
that.
on that aspect also you give reply. Heard Miss D. Majumdar, Miss R.D. Majumdar, learned counsel for the appellant. Also heard Mr. K. Bhattacharjee, learned counsel for the respondent. The hearing was substantially done. However, same could not be concluded. The appellant's counsel, learned counsel for the appellant, shall reply to the submissions made by learned counsel for the respondent on the next date fixed. Sure. कितना दिवो पड़े? 5th of May.
5th May.
5th May.
I'll oblige to-
No, just a minute. Yes, 5th of May. As let this matter be listed as part heard matter on 5th of May.
I'll oblige.
Oblige.
বেলেগ ফাইল বনাবো আৰু এইটো ভিতৰত দিব বাই স্লিপ যাব মোৰ লগত থাকিব লাগিব yes next matter 9 nothing
Item 43.
Please, your lordship. The matter may be taken another day. My understand the paper book applied to me today at 2 p.m. So it is difficult for
What paper book?
Your lordship,
Yeah. all evidences.
We have not called for the records.
Your lordship, can I have to see the order dated 11/12/25?
11?
11/12/25, my lord. I had taken responsibility to translate the vernacular cross examinations.
Okay.
I have
You
translated
have
the,
translated.
I have translated.
Who has certified it?
I have also filed the certified copy and translated both.
No, no, whether the translation is correct or,
My lord, I have given certificate, my lord.
okay. He is not contesting.
No, my lord. My lord, not only,
You have provided, furnished a copy of this.
my lord, provide.
They checked at 2 p.m. That's why.
No, that will allow. Heard. So you are seeking some another day.
Yes.
Heard Mr. L. K. Bora, learned counsel for the appellant. Also heard Mr. N. Alam, learned counsel for respondent number 1, who submits that in pursuant to the directions passed by this court by order dated 11/12/2025, the respondent number 1 has prepared a paper book by translating the copies of evidence which is available in the record. He submits that a copy of the paper book is furnished to the learned counsel for the appellant also today itself. One copy may be required for the court also.
Give me the copy, my lord, for court.
This is for court.
My lord.
He has also submitted a copy of the said translation for court records. Let it be kept in the records. Learned counsel for the appellant submits that since he has received the translated copies of evidence today only, he needs some time to go through the same. And on that ground, he has prayed for an adjournment. The learned counsel for the respondent has not opposed to the prayer. The prayer is allowed. Let this matter be listed
16. Hearing, my lord, for hearing.
for hearing on
5, if possible. 5.
5/5. It will be difficult. It will go in the month of July, 16 July.
We are having certain urgency. If possible, my lord, can we be accommodated? I have to do. Right.
Not so. 28th of May.
Much.
Item 44 and 45.
May please your lordship. Lordship, yesterday, in fact, I had informed my learned friend that I was not in good health. I'll not be able to do it, lordship. But he wants to begin his case. Lordship,
Lordship, there is a 2 cases, lordship, and one
appeal and cross appeal.
One appeal from claimants, right? For just enhanced lordship, that monthly OS has been taken 6,000. But daily OS has been excluded.
No, Mr. Goswami, now what is your prayer? Will you be able to argue?
Not today, lordship. That's what I had also.
Then we'll give a
To keep that in mind that
short date. Short date.
after the Bihu.
Lordship, in this case, Lordship, no payment has been. So that's why, Lordship, if possible after Bihu vacations, if possible, Lordship.
I'm not. Whenever.
No, it will otherwise be also after Bihu. Before Bihu, it is not possible.
Yes, Lordship. After Bihu, Lordship, this month I am.
4th June.
Lordship, that is too long.
Third, Mr. I. Hawk, learned counsel for the appellants. This is under what? Workman
Yes,
compensation?
yes, Lordship.
Agot Parine Saxon. Also Mr. R. Goswami, learned counsel for the respondent, who prays for an adjournment on the ground that he is not feeling well today. Considering the submissions made by learned counsel for the respondent, the prayer is allowed. Let this matter be listened. 28th of May.
Lordship, I think 28th of May, I think Lordship it's either 27 of April. Lordship, if possible, before 27.
Let it be on 4th June. 4th June.
Lordship, highly appreciate. So,
আরো কেইটা আছে? মিটিং আছে। Yes. Both of you are ready or not?
Otherwise ready. It will take some time. Actually. I can start. No problem.
You are not ready.
Not yet.
You are ready or not?
Yes, I'm ready. I can.
How much time will it take?
It will require a final hearing by order because the evidences are there.
Because today I have to rise at 4:30.
Any date, your lordship.
4:30, I think it is concluded, Your Honor. Your Honor, this matter is the petition, whatever the.
Testamentary interstate case.
Yes,
Yes, interesting. Issue involved is very simple otherwise.
very simple, Your Honor.
Okay, we'll start.
Yes, madam. But the
If,
issue, madam,
if you cannot finish it,
Yes.
then I will not keep it parted.
Oh.
On that condition. If you finish it, we'll deliver the judgment. Agreeable.
Any date as your condition. To any date.
You know, every time the matter is.
What is the matter? Tell me.
Yeah,
What is the fact? What are the facts?
Pilot, there are two wife pilot. That is the issue, pilot. This appellate number 1 claims that she is the first wife pilot.
She is the first wife.
First wife. Now, the respondent, wife pilot, she said pilot, she is the first wife and legally married wife. And the court below has come to the conclusion that her marriage has been legally constituted and I could not prove the date of my marriage, pilot. That is the issue.
Shows
Otherwise, my son is also been provided with the benefit and they have been provided with the benefit. That is
the
the
son
issue.
will otherwise also get legitimate or illegitimate, both sons.
Yes, they will get. Now, here, my lord, the issue, my case mainly bank on the, my lord, exhibit 4, my lord, annexure C, my lord, which we made exhibit, my lord, of their petition, your honor. They filed petition before the Motor Accident Claims Tribunal, where they made this appellant, my lord, Sonamuti Baspor, my lord. That is, my lord, the appellant number 1, my lord, the Sonamuki Baspor, my lord, page 22, my lord, as the respondent number 3, opposite party number 3 being wife of Madan Baspor, my lord. Now, they are admitting I am the wife, my lord. There is, I think, there is no issue about it. They have admitted. Things which are admitted may not be required to be proved in such a issues, such cases. Then, my next issue, paragraph number page 23, my lord, of the same petition. No, my lord, paragraph number page 25. Page 25 of this same MSCT application filed by them. Any other?
No, in the memo of appeal, which page?
Page 25.
Yes.
Yes. That is any other information. As per information received, Madan Baspor married Rekha Baspor, that is the respondent wife, you know, in 1990. But as Rekha Baspor was minor, so marriage, some dispute arose, and she left her parents' home. After Madan Baspor married Sonamuki, that should be Sonamuk. That is the
Who are you?
appellant number 1, your honor.
Okay.
Claiming to be the first wife, your honor.
sometime in 91, 92, but Sonamukhi Baspor was not staying with Madan Baspor, and Madan Baspor again married Rekha Baspor. That is important here. It is their version, their statement. It is their statement on both here.
But marriage was in the year 1990 itself.
So they are saying here that they were minor, so there was no marriage in the finding also court below it has come here in the trial court that since she was 16 or 17 years old at the time of marriage, so that marriage cannot stand
Why?
the legal. Minor,
It
it is
is-
minor, how it will be.
Minors marriage, whether it is a void, it is not a marriage void ab initio.
Of course not void of marriage. But her statement, she said, my lord, though got married in 1990, but she left. After that, married the appellant number 1, Your Honor. When appellant number 1 left, that is her version, then Rekha Baspor got married, Your Honor.
Okay, let us hear it.
That is the.
May I please your lordship?
No, let him, you have completed, Miss.
Complete.
No, he has not yet started.
This is the introduction I have given you. Now, let us. I'll go by ground first, then I'll go to the issues here. Issue 1 and 2, I'll read how the court has come to the conclusion. My grounds, of my memo of appeal, ground number.
Who filed the succession case?
Myself, my lord, this Sonamukhi.
You are Sonamukhi.
Yes, Sonamukhi, and there are two sons.
And your succession case was dismissed.
Therefore also filed, my lord. I mean, succession was allowed to my son, my lord, but not me, my lord. Not,
As well as to the sons and daughter, as well as
yeah, the respondent.
respondent.
Yes.
Respondent was allowed to inherit the.
Yes.
Okay.
Court has come to the conclusion that I could not prove the marriage, and she proved her marriage, that she has got legally married. My lord, my ground number 4 and 5, I'll read, my lord, then I'll go to issue, Your Honor. I've taken the ground. Ground number 4, your lordship got it, my lord.
Page number?
Page number 4. 7 grounds. Page number 1.
Yes.
For that the learned court below, while discussing the main issue, namely issue number 1, whether the applicant number 1, Sonamukhi Baspor, is legally married wife of deceased Madan Baspor, and the issue number 2, this issue, my lord, main issue, and I'm discussing the judgment also, whether Rekha Baspor is the first wife, legally married wife of Madan Baspor, has failed to consider the vital document of exhibit number 4. Just I have gone through that document. That is MSC case number so and so, filed by the respondent, where specifically stated by the respondent that respondent number 1, namely Rekha Baspor, got married with the deceased Madan Baspor in the year 1990, but as she was minor, so dispute arose. Rekha Baspor left for her parents' house, and after that, Madan Baspor got married to appellant number 1, namely Sonamukhi Baspor, in the year 1991-92. I quoted that thing, Your Honor. Going by the statement made by the respondent in MSC case number so and so, which has been brought on record by the appellant and also proved the same as exhibit 4, but the learned district judge neither considered the same nor even mentioned the same in the appendix of the impugned judgment as exhibit, despite of same being proved by the appellant, Your Honor. That no whisper has been there, Your Honor. It has been proved as exhibit, Your Honor. Therefore, the learned court below seems to have been acted in biased manner in passing the impugned judgment dated so and so. Therefore, same is liable to be interfered with. Next, my lord, this down. It is a matter of fact that and record that the appellant is a legally married wife of late Madan Baspor, which has been well established by the oral evidence as well as by the exhibit 4, where not only the appellant number 1 was.
No, what is the date of your marriage?
Yes, my date of marriage, that is
They say it is, I could not prove it, 27/10/1990, and I say it is 1910/1990. Orally. Of course, no document will be. 1910/1990. Though the year was mentioned 91/92, but the appellant number one stated to have got married in 1910/1990, proved by oral evidence. These aspects have not been looked into considered by the learned trial court, and thereby arrived at a purpose finding, and same is liable to be taken care of by your lordship. Now, my lord, I'll go to the judgment, because exhibit 4 I have already read here.
Okay, now what was the date of marriage of the respondent?
Of course, as per that is in January. My one is October, their one is January. January 1990. That is while she was minor. That is how they proved, that is
Okay.
issue number 1 and 2. I will read one. This is the main issue, whether the applicant Sonamukhi, page 32, turning page, memo of appeal. Issue number 1 and 2, whether the appellant Sonamukhi Baspar legally married wife of the deceased Madan Baspar, or 2, if not, whether Rekha Baspar is the first legally married wife of Madan Baspar. Well, this issue started from page 33, next page. How the learned trial court has come to discuss this. Issue number 1 and 2. Your lordship got it, my lord.
Yes.
It is the case of the applicant that late Madan Baspar during his lifetime married Sonamukhi, and Sonamukhi Baspar is the first legally married wife of late Madan Baspar. In support of their case, Sonamukhi Baspar, PW1 deposed that she was the first and legally married wife of Madan Baspar, and applicant number 2 is their son. She further deposed that she was granted monthly maintenance of ₹300 per month on 6/8/1993 by learned family court. At the time of death of her husband, left behind the applicant number 2 and opposite parties. She proved the death certificate of Madan Baspar by exhibit 1, but in the said certificate, the name of wife of Madan Baspar has been shown as Kaushilya Baspar, which is not a fact. Since Kaushilya Baspar is mentioned, he is the mother of late Madan Baspar. She further exhibited the certified copy of order passed in the maintenance case exhibit 2, from where it is seen that monthly maintenance of 300 was allowed to her, which was filed against late Madan Baspar. In cross-examination, PW1 deposed that they were residing at GMC colony at Patasil Ambari along with her son, applicant number 2. She further deposed that before the death of late Madan Baspar, he used to reside with her and late Madan Baspar expired due to high pressure at Bhorolmo. She categorically deposed that she was married to late Madan Baspar in the year 1990, and she admitted that she could not collect the date of her marriage. She further deposed that marriage was solemnized as per social rite at Maligaon near Pandu, Gauhati, where family member of her husband were present. She also deposed that after marriage, she stayed in with the late Madan Baspar as married couple for 7 years, and she knew Rekha Baspar too. PW1 further deposed that Rekha Baspar was second wife of her deceased husband, but could not say as to how and when her husband married Rekha Baspar. She also deposed that she was not married to any other person before her marriage with late Madan Baspar. After 7 years of her marriage, she lived separately. She further deposed that she collected the death certificate of her husband from the office and Kaushilya Baspar was mother of late Madan Baspar. She also admitted that Rekha Baspar has one son and one daughter, and who are Rajesh Baspar and Pooja Baspar. From the evidence of this witness, it is clear that according to her own testimony, she was married in the year 1990. However, she could not say as to on which date her marriage was solemnized with late Madan Baspar. To support her evidence, Gwala Baspar filed his evidence on affidavit, but the said witness did not turn up to face the cross-examination, for which evidence of witness has no credibility. However, in his evidence, he only deposed that he attended the marriage of Sonamukhi Baspar with late Madan Baspar, solemnized at Pandu colony socially in the year 1990. The witness is also silent as to the date of marriage of Sonamukhi with late Madan Baspar. Another witness, Balaji Baspar, PW3, deposed that late Madan Baspar was his uncle and late Madan Baswar used to come to the house of Sonamukhi Baswar on maximum days in a week with ration in his hand and used to stay there, though they had court cases. These witnesses further deposed that on other days, late Madan Baswar used to stay in the quarter of Maligaon along with his mother and brother. He further deposed that late Madan Baswar told him that he used to come to the house of Sonamukhi Baswar for his wife and son, as his brother and other family members did not like Sonamukhi Baswar. It is the testimony of this witness that applicant number 2, Arjun Baswar, son of late Madan Baswar, out of their wedlock with Sonamukhi, and to his knowledge, till death, late Madan Baswar maintained relation with Sonamukhi Baswar. In his cross-examination, he deposed that he came to know from his father that Madan Baswar married Sonamukhi, and he had also personal knowledge of late Madan Baswar married her. He also deposed that he heard that there was social marriage between them and used to frequently visit the house of late Madan Baswar, and on many occasions he met him in the house of Sonamukhi Baswar. He categorically denied to have any knowledge regarding the marriage of late Madan Baswar with any other woman. He also admitted that he had no knowledge that late Madan Baswar and Sonamukhi Baswar were living separately for more than about 20 years. Besides, he admitted that Madan Baswar used to stay with his mother and brother at Maligaon prior to his death. From the evidence of all the aforesaid witness, it can only be concluded that late Madan Baswar married Sonamukhi sometime in the year 1990. Date is not there, that is, I have to admit. There is no documentary evidence adduced by the applicant to show the exact date of marriage of Sonamukhi Baswar with late Madan Baswar. The evidence of PW3 cannot also trustworthy relied upon, since he admitted in his cross-examination that he heard that there was a social marriage between Madan Baswar and Sonamukhi Baswar, and these witnesses completely silent as on which date the said marriage was solemnized between Madan Baswar and Sonamukhi Baswar. On the other hand, Rekha Baswar, that is the respondent number 1, in her evidence categorically deposed that she was married with late Madan Baswar on 19/1/1990, prior to 10 months before our marriage, at village Goripa, West Bengal, following all rites and ritual in the presence of her family member, after which marriage was registered on 24/1/1990 before the municipality commission. Now, that is an issue, my lord. How municipality commissioner can be a marriage officer? That issue I have also raised, Your Honor. She further deposed that she never abandoned her husband. Out of their wedlock, opposite party number 2 and 3 were born. In support of her evidence, she produced the certificate of marriage issued by Manik Chandra Das, who was commissioner of Halishahar municipality, showing her date of marriage on 19/1/1990 in her cross-examination. She reiterated that she got married on 19/1/1990, and at the home at the time of her marriage, she was about 15 and 16 years old. Now, these issues may be required to be taken into consideration. Whether registration of a minor can sustain you.
No, otherwise there is evidence that marriage was performed by following all the rites and rituals.
That is there. That is, we have also said that our marriages also. But in our by her own statement in the MSc case, she said since she was minor, so she left. There was some problem. And
now what will happen to the marriage?
Madan Baswar married to me. After I left, she again got married. That means she got married after me. She on her own.
No.
She said that is my case.
What is your submission regarding the first marriage when she was 16 years of age?
No, so my humble
That
submission,
marriage cannot be automatically invalidated.
of course not, unless it is, yes, I understand. That is all. But that is also another important thing, manner how commissioner of Halisapur municipality, by Lord, can be a marriage officer. How issue marriage certificate. That also was required to be proved by Lord. I don't know how he does bypass. It has been proved as exhibit, by them. But how municipality commissioner, under what authority, probably there's, that evidence are not with me in the record, probably they have that evidence. Your Honor, regarding his designation, Your Honor, all cross-examination is there, I think. In the, because I don't have the evidence, Your Honor. Evidence of this, this document regarding Manikchandra Hakideshin, no? Yes, this, in video calling Manikchandra Das, Your Honor, those questions were put to him, Your Honor, regarding his authority, Your Honor. He could not reply, my lord. This is one of my ground, Your Honor. The person who issued the certificate, he was cross-examined, Your Honor. Some questions were put to him regarding authority. He could not say, Your Honor.
So suppose that is ignored.
Yes, that certificate go.
Even if that certificate goes,
Yes.
still other evidence is there.
Otherwise, she said that prior to 10 months before, Mr. Mayor. But at that time, then I will rely her statement of the MSc case, Your Honor. She said she left, Your Honor. After
She
that,
may
could-
leave. She may leave.
Of course, then why the second time she has to go get married with me? With the Madan Baswa. Oh, her own statement said so. That is not my statement, Your Honor. I may read just line, Your Honor.
So what is your submission?
My submission that is that since if I will rely her statement on this case, MSc case,
That
application
is
she had filed.
married
No, she
for the
said,
second time also.
yes.
So
What?
what happens to her first marriage?
Because that means there was no marriage at first, that is on 1990. Otherwise, there would not have been a second marriage, Your Honor. Where is the requirement of a second marriage, Your Honor? And you see, Your Honor, this is very important, Your Honor, that Madan Baswar again married Rekha Baswar and continued his conjugal life after filing divorce with Sonamukhi. She said, after divorcing me, she got married. Where her statement will go, Your Honor? I will rely her statement. And kindly see the marriage certificate, Your Honor, that PW, that is probably his witness is there, Your Honor. He was sufficiently cross-examined. And that person could not say his authority of issuing the certificate, Your Honor.
Okay.
So these aspects also required to. That is the only issue, Your Honor, in this case.
Yes.
Subject to what my learned sister said. Okay.
Yeah.
That doesn't happen.
So may I plead your lordship? Lordship, whatever the appeals they have made, doesn't disclose any illegality and preservability. Because as per this, High Court can interfere only when there is illegality, but when the evidence is ignored and law has been misplaced. As per my learned counsel said, the evidence has been ignored. And what the ignorance was made, as per them, they have filed a MICT petition, and which is a pleading only. The petition was a pleading of a party only. And it can be considered as a evidence without any proof, Your Honor. First of all. Second thing, the Honorable Judge has considered all the detailing, consider all the evidence before passing this judgment, Your Honor. Main thing regarding the minor issue. So in this petition, at page number 12, the Honorable Court at Petson, they also give a opportunity to prove the part also, and that is properly applicable the principle of burden of proof over them when the regarding the minority issue was
Page number?
Page number 12, Your Honor.
12 of the memo of appeal.
Judgment. I have the judgment number 40, para 14 of the judgment. Memo.
Just a minute.
So here it is mentioned, Your Honor, in the last part, that principle is stipulated in section 101 of evidence and provided the define the burden of proof. Section 102 of Evidence Act 1872 stipulated that the burden of proof is suit for the proceeding lies on that person who would fail if no evidence at all were given on the other side. So they give an opportunity regarding this, and they are failed to prove anything regarding this minor statement. And mere statement, whatever they given
without any evidence and proof, it can't consider doing.
No, suppose even if we assume that she was minor,
Yes, Your Honor.
what will happen to her marriage?
It
Whether
also,
he,
it also valid because marriage cannot, as per the law of marriage, it can be become void ab initio. If any party of this marriage is means approach to the means a court, and then only it can be considered as a void. So without that, the marriage, if the
minor's marriage is a void marriage or voidable marriage?
voidable marriage.
Voidable marriage. Okay. Yes, proceed.
And again, so in their petition, Your Honor, whatever the petition, the appellant is filed the succession matter. We are the opposite by respondent there on, Your Honor. During the time of filing the petition, they have placed one document only, that is the death certificate of the Madan passport. In the petition itself, they never mention their date of marriage, Your Honor. In the cross also, and at the time of evidence also, they are failed to prove their date of marriage, which is a major issue in this matter. Because
Why? Why it is major?
because in the petition itself, the means
Why date of marriage was necessary?
because as per the rule of succession, the first wife is only entitled for the yes, the succession benefit. That's why, and their appellant is filed the petition and saying that there are two wives. They herself state that there are two wives in their petition, but in the petition itself, she did not define her marriage. In the cross evidence also, she failed to prove the date of marriage. Every time they have filed some petition, means a pleading of matrimony, maintenance and all regarding maintenance order, everything. But maintenance order can assume that there is some relation between Madan Basper and the Sonamukhi Basper, but it can't give any proof regarding the date of marriage, Your Honor.
Okay.
So again, so my submission is I don't have time also, because as per my conclude my submission that they want to re-agitate and reappreciate the evidence, the trial itself. They have get sufficient time, Your Honor. And they are failed to place any substantial question of law which is very much necessary to accept this application, Your Honor, petition, Your Honor. So in the issue also in page number 7, it is clearly mentioned that they have exhibit only 2 documents at the time of evidence. In the memo, it is, what is the memo? Para number 7. Para 7. At page number 33 of the memo, Your Honor. Para 7. It is mentioned that they have submitted 2 exhibits. One is the death certificate, which is also of Kaushalya Basper. And Kaushalya Basper is given evidence on behalf of us, Your Honor.
Kaushalya Basper is
A mother, Madan Basper, who denied in her submission, in her cross, that she means appellant is her daughter-in-law. And again, next exhibit, they have exhibited one maintenance case. Here also they file some petition, Your Honor, pleading, that is pleading of the statement of the party, which can be considered as an evidence or proof of marriage, Your Honor. So I concluded my submission here that the honorable case, it correctly determined the means judgment, and based on this all proof and all the evidences, Your Honor. And the other side is failed to means make any substantial question and law, they say dismiss that. My prayer is to dismiss the petition.
Only one line reply.
Yes.
Only one. This type of appeal by interest appeal is the first appeal. It's a kind of regular first appeal. I can take all ground. No substance question is necessary. All factual and legal, everything can be taken. No, my contention will remain the same. Why? That she is also the wife. I made parties. They also made me party as wife. They themselves written.
No, whether second wife will inherit.
She herself said, Your Honor, she got married after my divorce. That is the case.
So the contention is
statement.
that who is the first wife?
Yes.
That is to be, but
I
you have,
rely her statement.
but you have not mentioned the date of your marriage.
Of course, because, of course, that is.
Okay, heard
a matter of
Mr.
fact.
A. Chaudhary,
Yes,
A.U. Chaudhary, learned counsel for the appellant. Also heard Miss L. Das, learned counsel for the
Respondent.
all the
1 and 2.
learned counsel for the respondents. There are 3 respondents.
Your sister. One is son of Rekha Baspar, another is daughter of Rekha Baspar. All are getting share in this.
Learned counsel for all the, you are appearing for all the respondents. All the respondents. This appeal under section 299 of,
I corrected probably 384.
huh?
384.
No,
Oh, it has been corrected, correct pronunciation. Yes. It is actually, amendment has been made here. It is 384.
384.
Yes.
Okay. Succession Act sum. You have filed amended plain
Yes, yes.
Indian Succession Act.
Actually, after that, it has come for the hearing. Yes, no? Amended cost title has been given.
Under section 384 of the Indian Succession Act 1925, impugning the judgment and order dated 4/10/2024 passed by the Court of London, District Judge 384 allows. 384 passed by the Court of London, District Judge Kamru Metro at Gauhati in succession case number 134/2017, whereby the appellant was, whereby the who is Arjun Baswar?
Son, yeah.
He's getting,
Yes.
He got a share.
Good.
Where-
Except, the Sonam.
whereby the application filed by the present appellants under section 372 of the Indian Succession Act for inheriting the properties of late Madan Baswar was partially allowed, and the appellant number 1, Sonamukhi Baswar, was not was Sonamukhi Baswar
Page 45, man. Well, left of point.
who was found to be was not Sonamukhi Baswar was not found to be entitled to
Yes.
Yes, appellant was not
inherit the debts and securities left behind by late Madan Baswar. by the impugned judgment, it was held that the present respondent number one, Srimati Rekha Basfar, and her children, namely Rajesh Basfar and Pooja Basfar, along with her mother-in-law, namely Kaushalya Basfar, were entitled to inherit 1/5 of shares of the debts and securities left behind by late Madan Basfar. The appellant number 2, Arjun Basfar, was also found entitled to receive 1/5 of shares of the debts and securities left behind by his father, late Madan Basfar. Where is the copy of petition file?
My copy of succession. Yes, yes. That is my lord, page 12. Annexure A. Section. Page 12. Annexure A.
The facts relevant for consideration of the instant appeal, in brief, are that the present appellants, namely Sonamukhi Basfar and her son, namely Arjun Basfar, filed an application under section 372 of the Indian Succession Act 1925, claiming the succession certificate in respect of the debts and securities left behind by late Madan Basfar, who had expired on which date he expired?
Married on 21/9/2016.
On 21/9/2016
At Gauhati.
when Gauhati. Stop. In the petition filed, in the aforesaid petition filed by the present appellants. No. In the aforesaid petition filed by the present appellants before the trial court, that is the Court of Learned District Judge, Kamrup Metro, it was contended that late Madan Basfar was the husband of the appellant number 1 and father of appellant number 2. Stop. He was working as J/peon in capital FA and CAO. What is this FA CAO? FA/FA and CAO office, NF Railway Maligaon. It was contended by the present appellants that the appellant number 1 was first and legally married wife of late Madan Basfar, and it was further contended that she was married to late Madan Basfar in the year 1990. However, no specific date of marriage was stated in the aforesaid application. It was further contended that the it was further contended in the said petition that late Madan Basfar married for the second time the respondent number 1, namely Rekha Basfar, and out of the said wedlock, 2 sons, one son and one daughter, namely Rajesh Basfar and Pooja Basfar, were born. It was also contended that late Madan Basfar died intestate, and therefore there was no impediment in granting succession certificate to the appellants. Stop. The next para. The present respondents contested the claim of the appellants in the aforesaid case within bracket succession case number 134/2017 by filing written objection. Wherein it was contended by the present respondent that respondent number 1 that she was married to Madan Basfar on 19/1/1990 and the respondent number 2 and 3 were born out of the said wedlock. It was also contended that the present appellant number 1 fraudulently got married to late Madan Basfar on 27/10/2019, no, 27/10/1990, knowing fully well that at that time he was having a legally married wife, that is the respondent number 1. It was also contended by the present respondents in their written objection that the marriage of respondent number 1 with late Madan Basfar was also registered by the Commissioner of Asilapur, Hali Shahar, Commissioner of Hali Shahar, HALISAHAR municipality, and a certificate to that effect was also issued to her on 24/1/1990. Accordingly, it was contended that the respondent number 1 was not entitled to get any succession certificate in respect of, no, accordingly it was no, that the appellant number 1 was not entitled to get any succession certificate in respect of debt and securities left behind by late Madan Baswar. Stop. Next para. On the basis of the pleadings of the respective parties, the Court of Learned District Judge Kamrup framed following issues. Court A from page number 32. Page number 32 from the memo of appeal. In support of their contentions, the present appellants examine 3 witnesses before the trial court, namely the appellant number 1 as PW1, 1 Goara Basfor as PW2, and 1 Lalaji Basfor as PW3. Whereas the respondents adduce evidence of Rekha Basfor, Chaneshwar Basfor, Rajesh Basfor, Kaushalya Basfor, and Manik Chandra Das. However, by the judgment and order dated 4/10/2024, the Court of Learned District Judge only partially allowed, Court of Learned District Judge disposed of the application filed by the present appellants under section 372 of the Succession Act, Indian Succession Act, in the manner as already described in the foregoing paragraph herein before, foregoing paragraphs of this judgment. The aforesaid judgment has been impugned in this appeal. Dot, dot, dot. Remaining what is to be done? Meeting us here, okay. I'm listing it again on 5th of May for some queries. 5th of May. I'm not showing it as part heard. In the meanwhile, I'll go through it. And if some queries are there, I may pose it. Otherwise, I will deliver the judgment. List this matter. Now, heard so and so. A.U. Chaudhary and Eldas. The hearing is substantially done. List this matter as part heard matter. Some queries may be there, I will pose. Part heard matter on 7th of May. 7th of May. Thursday. List accordingly. এই রেকর্ড তো ভিতরত দিব